Okay. So if I were to decide to waive it, then that would just start the 30 days?
Right.
Okay, okay. And the alternate is just to go back to Kansas and,
Well, so if you don't waive, I will go ahead, I will set that bond, the cash only appearance bond, in the amount of $25,000. All right. And then you will, if you're able to post that bond, you do need to show back up for that June 1st hearing at 1:30, that extradition hearing. If you are still in custody on June 1st, you will be transported for that hearing. All right. And that's the hearing that starts the governor's warrant process going.
okay, okay, that makes a little more sense. So essentially, same process. One is just requiring governors to, and then the other one's just taking on, just essentially waiving that. And
Yes.
okay,
But then I don't know if you're in custody on any other charges. Okay.
I'm not.
Okay.
So I would say that is a tough decision to make. Okay. Um, I want to do whatever's going to get this taken care of the fastest. I think that probably just just do the waiver and just kind of dealing with it would probably be the best route to go.
Okay. If that is your decision,
Um,
I cannot provide you with legal advice, so this is a decision you have to make for yourself.
okay, okay. The, with the waiver, what reason would someone normally choose to wait for the government for the governor to sign? Is there
I don't know why people make their decisions and why they don't. Some people have charges pending that could impact this decision. Some people may feel that my bond is unreasonably high, in which case, when you see the judge at the extradition hearing, she can change that bond amount.
okay, okay, okay. Let's do.
And there might be other reasons that other folks have. I don't know. It's certainly not an exhaustive list.
Right, right, right. Um, uh, so it makes sense for me to do. I'm so sorry. I don't mean to be the person to.
And some people just aren't ready to make the decision, and that's okay.
Yeah.
You'll be offered this choice again.
Okay. Okay. Is it if I wait, is it going to slow down the process? I just want to. If I don't want this to have to take longer than it needs to.
So the governor's warrant process can take up to 90 days.
Okay. And then that's if I decide to wait. If I just waive it, then it's the 30 days.
It's the 30 days. They have 30 days to come for you. Now they can request a few extra days, but it's basically 30 from tomorrow.
And that's if I waive.
That's if you waive.
Okay. Okay. We'll just go ahead and waive.
Okay. All right. I understand at this point you do want to sign the waiver of extradition. I will need to ask you some questions as I am making a record of the proceeding. Did you read the waiver of extradition paperwork?
Yes. Yes.
Do you understand that you do not have to sign the paperwork?
Yes, I understand.
Do you understand that you have the right to an extradition hearing?
I do.
Do you understand that you have the right to hire a lawyer at your own expense?
Yes.
Do you understand that you have the right to demand that a governor's warrant be signed by the governors of both states before you are returned to Kansas?
Yes. Yes, I do understand that.
All right. Do you understand that you have the right to bail, which in this case would be a cash-only appearance bond in the amount of $25,000?
Yes. Okay.
Do you want to give up those rights and sign the paperwork?
Yes.
Okay. Has anyone threatened you or promised you anything to get you to sign the paperwork?
No.
Have you had any drugs, alcohol, or medication within the last 24 hours?
No.
I find that you knowingly, intelligently, and voluntarily are signing the waiver, and I'm also signing it. I am directing the sheriff's office to notify the requesting state that you are ready to return. Kansas will have 30 days from tomorrow to pick you up unless there are local charges pending. If there are local charges pending, the 30 days will not start until the conclusion of that case. Do you have any questions?
No, I don't know.
Okay. I will go ahead and update my part of the form. Okay, and we should be ready for you to sign it up here.
So there's a signature pad right in front of you. Go ahead and grab that, and then you're going to sign twice. Go ahead and sign the first time. I believe it should work with the signature.
Okay, we just have to add.
Okay, go ahead and sign that second time.
All right, sir. The officer should have your paperwork. If you want to go ahead, step to left. Good luck to you.
Thank you.
Visit Superior. Good morning, interpreter. This is Commissioner Campbell. Can you hear me okay?
I hear you fine, ma'am. Thank you.
All right, perfect. Let's go ahead and get started. Christian Villalba Castaneda, please.
¿Podemos hablar con De Alba Castañeda, por favor? Soy un intérprete.
All right, and oh, thank you. All right, Mr. Castaneda, will you go ahead and state your name for the record?
Gracias, señor Castañeda. Por favor, declare su nombre para el acto.
Aquí. Cristian Eduardo Villalba Castañeda.
Eduardo Villalobos Castañeda.
And Mr. Castaneda, what is your date of birth?
Yep, the interpreter will verify, ma'am. I'm not sure I heard that right. You said date of birth?
Yes, sir.
Ok, su fecha de nacimiento, señor Castañeda.
19 de julio de 1992.
July 19, 1992.
All right, so you are here on a Maricopa County Superior Court new case.
Bueno, usted se encuentra aquí porque hay un nuevo caso en contra de usted en la Corte de Maricopa.
You were arrested yesterday on charges of theft of a means of transportation, a Class 3 felony.
Usted se encuentra detenido aquí porque se le han presentado cargos en su contra por robo de un medio de transporte, que sería un delito grave o un delito mayor de categoría 3.
I did find probable cause for that. I am appointing you an attorney.
Yo fallo que hay causa probable y le he nombrado un abogado.
I am setting hearings on June 4th at 8:30 and June 8th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. Will you go to those?
Le estoy programando 2 audiencias, una para el 4 de junio a las 8:30 y el otro a las, perdón, el otro el 8 de junio a las 8:30 también. Las 2 de las audiencias se llevarán a cabo en la Corte Superior del Condado de Maricopa en Downtown Phoenix, el centro de Phoenix. ¿Irá usted a las audiencias?
Sí, claro.
Affirmative. Of course.
All right. Then based upon your promise to appear, I'm going to go ahead and release you today to the supervision of pretrial services.
Bueno, entonces, con su promesa, yo lo pondré en libertad el día de hoy bajo la supervisión de los servicios preliminares de los juicios, que son pretrial services.
Pretrial services will do electronic monitoring.
Bueno, y el servicio pretrial service, this is Andrew Burgess to verify, I apologize. You said they will not do monitoring?
No, they will do electronic monitoring.
Okay. Discúlpeme, el servicio preliminar de la corte lo que hará será un servicio de monitoreo electrónico.
You're not to return to the scene of the alleged crime or have any contact with any alleged victim, complainant, or witness.
Usted no podrá regresar a la escena del presunto delito, no podrá tener ningún contacto con ninguna de las víctimas, querellantes ni testigos del delito.
You're not to possess or consume any drugs without a valid prescription, no alcohol, and no marijuana, THC, or CBD products without a valid prescription.
Y tampoco podrá tener posesión ni consumir drogas en una receta o prescripción válida, no podrá consumir alcohol, marihuana, THC, THC, ni CBD, CBD, sin una receta válida.
All right, go ahead, step to left, officer has your paperwork for you.
Bueno, entonces puede pasar y vamos a darle el papeleo para ponerlo en libertad.
All right, interpreter, thank you so much for your assistance this evening. We really appreciated it.
You're welcome. Thank you for using the services. Have a wonderful night. Thank you.
All right. And do we have Ms. Sauer on the phone?
Yes.
Okay.
I'm here, Your Honor.
Good morning, ma'am. All right, we are waiting for, we're going to take Ms. Howard first. We're waiting for her to be brought in. While we're waiting, I'm going to go ahead and read the house. Oh, she's here. Never mind. All right, Ms. Howard, come on up. Podium right there. All right, ma'am, I'm going to remind you that you do have the right to remain silent. Anything you say could be used against you. All right, go ahead, state your name.
Sapphire Howard.
And Ms. Howard, what is your date of birth?
9/13/97.
Thank you. And on behalf of the state this evening?
Dawn Sauer on behalf of the state, Your Honor.
Thank you. All right, Ms. Howard, you are here because you, on a Superior Court new case, you were arrested on charges of sexual conduct with a minor, a Class 4 felony, 2 counts of sexual abuse, both Class 5 felonies, and 1 count of furnishing obscene materials to a minor, Class 5 felony. Based upon the information contained in the Form 4, I am inclined to find probable cause for those violations, but I will hear argument from the state if Ms. Sauer would like to make any argument.
Yes, Your Honor. In addition to the written recommendation that the state submitted, the state wanted to point out that the defendant is about double the age of the victim. The victim is a teenager, and the defendant preyed upon this victim and appears to have been grooming him over the course of several months. The state believes she is a danger to the victim, a continuing danger to the victim and to the community at large, especially other teenage boys. The state is requesting a $100,000 cash only bond, and if posted, no contact with the victim, electronic monitoring, and no contact with any minors whatsoever.
Thank you. All right. I am going to go ahead and find a probable cause for those violations. I am going to appoint you an attorney. I am setting a status conference on May 28th at 8:30 and a preliminary hearing on June 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. I must now consider and decide terms and conditions of release. In order to do that, I have heard argument from the state. I have also reviewed the state's written recommendation. There's also a victim statement in this matter. I have reviewed all of those. Ms. Sauer, did you want to make any additional argument?
No, I have not
Yeah, Your
talked to a lawyer. Oh, sorry.
All right. Then based upon the information in the Form 4 and the other and state's argument and victim statement, as well as state's written recommendation, I do think the state's recommendation is appropriate in this case, and I'm going to go ahead and set a cash only appearance bond in the amount of $100,000. In the event you are able to post that bond and secure your release, you would be subject to certain pretrial release conditions, including electronic monitoring. You're not to return to the scene of the alleged crime or have any contact with any alleged victim, complainant, or witness. You're not to have any contact with any minors. There are no exceptions to that. You're prohibited from accessing the internet except for school, work, and court purposes. You're not to possess or consume any drugs without a valid prescription, no alcohol, and no marijuana, THC, or CBD products. All right, anything further from the state, Ms. Sauer?
No, thank you.
All right, Ms. Howard, if you go ahead, step to the left, officers do have your paperwork for you. All right, and while we are waiting for Ms. Martin, I'm going to go ahead and read the house call in. We do have one house call this evening. Ashley Cruz. Ms. Cruz is unable to function for purposes of appearing here in court this morning. Her date of birth is August 27th of 1994. I am finding that she is a danger to self or others or otherwise not able to function for purposes of court, so I will conduct her hearing at her cell. Ms. Cruz is here on a on a warrant out of the Maricopa County Superior Court in a direct complaint matter. That direct complaint alleges that she committed the violations of possession of narcotic drugs, a Class 4 felony, and possession of drug paraphernalia, a Class 6 felony. I am appointing her an attorney. I am setting hearings on June 4th at 8:30 and June 8th at 8:30. My intention at this point is to release Ms. Cruz on her own recognizance. If anything changes after I talk to Ms. Cruz in-house, I will update my written order in her case. All right. And Ms. Sauer, we are still waiting, and while we're waiting, I'm going to call on a DUI warrant, so we're going to go off the record. Could we go off the record just for a minute? Miss Martin, come on up. All right, Miss Martin, go ahead, state your name.
Kimberly Martin,
And Miss Martin, what is your date of birth?
October 1st, 1998.
Thank you. And on behalf of the state this evening, Miss Sauer?
Sauer on behalf of the state, Your Honor.
Thank you. All right, Ms. Martin, you are here because on a Superior Court new case based upon charges of murder in the first degree, a Class 1 felony. Based upon the information in the Form 4, I am inclined to find probable cause for that. But I will go ahead and hear argument from Ms. Sauer on probable cause if you would like to make any, Ms. Sauer.
I don't believe that's necessary, Your Honor.
All right, based on the information in the Form 4, I am finding probable cause for that charge. I am appointing you an attorney. I am setting a status conference on May 28th at 8:30 and a preliminary hearing on June 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. I must now decide and consider conditions and terms of release. In order to do that, I have, as I mentioned, reviewed the Form 4 in this matter. The state has also submitted a written recommendation. The state is recommending a bond amount in the amount of $1 million cash, along with electronic monitoring. I do believe, based upon my review, that that is appropriate. However, I have not yet made a decision, and I will certainly hear from the state before I do so. Ms. Sauer, do you want to make any argument on bond?
Your Honor, I did request the $1 million cash only bond. I won't repeat all of the details that I provided in the written recommendation, but the state does believe that's appropriate based on the age of the victim, the circumstances, and the defendant's actions in this case.
Thank you. All right, I do agree that that is appropriate given the factors in this case. So I'm going to go ahead and set a $1 million cash only appearance bond in this matter. In the event you are able to post that bond and secure your release, you would be subject to certain pretrial tests, certain pretrial release conditions, including alcohol and drug testing, as well as electronic monitoring. You're not to possess or consume any drugs, no alcohol, no marijuana, THC, no drugs without a valid prescription, no alcohol, no marijuana, THC, or CBD products without a valid prescription. You're not to possess any weapons. You're not to have any contact with any minors. All right, anything further from the state, Ms. Sauer?
No, Your Honor, thank you.
All right, ma'am, go ahead, step to left, officers have your paperwork. All right, that does bring us to the end of our 11 p.m. initial appearance calendar. And we are going to go ahead and stand adjourned until 2 a.m. and we are off the record.
All right.
I think you may be seated. All right, good morning. My name is Commissioner Elizabeth Campbell, and this is the 2 a.m. initial appearance calendar for May 22nd, 2026. The court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. Persons appearing before this court are reminded that they have the right to remain silent and that anything they say could be used against them. Most of you have qualified for a court-appointed attorney. If you have not qualified for a court-appointed attorney, or even if you have, you may retain an attorney at your own expense to represent you. I will be calling you up individually. When your name is called, please proceed to the podium. At the conclusion of your matter, officers will have paperwork for you. That paperwork will contain my complete orders in your case. It will also contain the dates, times, and locations of your future hearings. All right, I now need to read a victim's rights advisement. If you are the victim of a crime of the case pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on relief, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. All right, we are going to go ahead and start this evening with this morning with Michael Fulton, please, and then Dominic Tapia. Hey, all right, sir, go ahead, state your name.
Michael Amon Fulton, 12/7 of 1988.
Thank you. All right, sir, you are here because the Pinal County Superior Court issued a warrant for your arrest. Based upon allegations that you violated your probation in Pinal case CR 2025-00215. That is your case there. The underlying conviction is for possession of dangerous drugs. In that matter, I am indicating that an attorney should be appointed for you at your next hearing, which will be on May 28th at 8:30 in the Pinal County Superior Court. Pursuant to that Pinal County Superior Court arrest warrant, I am holding you non-bondable in this matter. All right, go ahead, step to left. Dominic Tapia, please. Hi. All right, go ahead, state your name.
Dominic Tapia,
And what is your date of birth?
11/01/04.
Thank you. All right, you are here on two matters. Let's talk about your new matter first. All right, you were arrested on charges of resisting arrest, a misdemeanor, and obstructing government operations, also a misdemeanor. I did find probable cause for both of those. I am indicating that an attorney should be appointed for you at your next hearing for limited representation regarding the bond issue only, because I am in this new matter setting a secured appearance bond in the amount of $50. I'm also setting a hearing in the Tempe for Guadalupe Municipal Court on May 28th at 9 a.m. Now, you are also here because the grand jury in Maricopa County issued a warrant for your arrest. Based upon allegations that on or about December 16th of 2025, you committed the offense of robbery, a class 4 felony, and assault, a class 1 misdemeanor. In that matter, I am appointing you an attorney, and I am setting an arraignment hearing on May 29th at 8:30 in the downtown Maricopa County Superior Court. Pursuant to that grand jury arrest warrant, I am setting a secured appearance bond in the amount of $75,000. In the event you are able to post that bond and secure your release, you're not to have any contact with any alleged victim. You're not to possess any weapons, no drugs without a valid prescription, and no alcohol. All right, go ahead, step to left. Officer has your paper. Oh, wait, come back. I am sorry. I skipped one. Thank you. All right, now you are also here because Maricopa County Superior Court issued a warrant for your arrest based upon allegations that you violated terms 3, 4, 5, and 15 of your probation in your Maricopa County case, CR 2025-133438. In that matter, I am appointing you an attorney, and I am setting hearings on May 28th at 8:30 in the downtown Maricopa County Superior Court. Now, in the event you are able to post your bonds and secure your release, I am reminding you, you are on probation, so you would need to contact your probation officer within 72 hours of your release. You'd also need to make sure you go to all of your hearings. You are still in custody on the dates of your hearings. You will be transported. All right, go ahead, step to left. Jonathan Robinson, please, and then Alexander Hensley.
Good morning, Your Honor.
Good morning, sir. Go ahead, state your name.
Jonathan Robinson,
And Mr. Robinson, what is your date of birth?
12/22/01.
Thank you. All right, sir. You are here on a Superior Court new case. You were arrested on charges of armed robbery with a deadly weapon, a Class 2 felony. I did find a probable cause for that. Based upon the information that you provided to pretrial services, I am finding that you are not indigent for purposes of appointing you an attorney. So I'm not appointing you an attorney this morning. You may, of course, retain an attorney at your own expense to represent you. I am setting a status conference on May 29th at 8:30 and a preliminary hearing on June 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. In your matter, I am setting a secured appearance bond in the amount of $50,000. In the event you are able to post that bond and secure your release, you would be subject to certain pretrial release conditions, including electronic monitoring. You're not to return to the scene of the alleged crime or have any contact with any alleged victim, complainant, or witness. You're not to possess any weapons, no drugs without a valid prescription, and no alcohol. You're not to possess any simulated weapons or any or possess or consume any marijuana, THC, or CBD products without a valid prescription. All right, go ahead, step to the left. Officer has your paper.
Thank you, Your Honor.
Alexander Hensley, please, and then Trevin Harleston. All right, Mr. Hensley, go ahead, state your name.
Alexander Hensley,
And Mr. Hensley, what is your date of birth?
March 12th, 2007.
Thank you. All right, sir. You are here on a Superior Court new case. You were arrested on charges of armed robbery, threatened use of a weapon, a Class 2 felony. I did find probable cause for that. I am appointing you an attorney. I'm setting a status conference on May 29th at 8:30 and a preliminary hearing on June 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. In your matter, I am setting a secured appearance bond in the amount of $50,000. In the event you are able to post that bond and secure your release, you would be subject to certain pretrial release conditions, including electronic monitoring. You're not to return to the scene of the alleged crime or have any contact with any alleged victim, complainant, or witness. You're not to possess any weapons, no drugs without a valid prescription, and no alcohol. You're not to possess any simulated weapons, and you're not to possess or consume any marijuana, THC, or CBD products. All right, go ahead, step to the left. Officer has your paperwork. Trevin Harleston, please, and then Expen Verduzco. All right, sir, go ahead, state your name.
Trayvon Austin, 08/30 of 2001.
Thank you, sir. All right, sir. You are here because on a Superior Court new case, you were arrested yesterday on charges of unlawful flight from law enforcement, a Class 5 felony, 2 counts of resisting arrest using physical force, a Class 6 felony, 1 count of reckless driving, a Class 1 misdemeanor, and driving with a suspended or revoked license, a Class 1 misdemeanor. I did find probable cause for all of those. I am appointing you an attorney. I am setting hearings on May 29th at 8:30 and June 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. In your new matter, I am setting a secured appearance bond in the amount of $50. Now, you are also here because you are currently on probation in your case CR 2024-129493. In that matter, your new charges would constitute an alleged Term 1 violation of your existing probation case. In your probation matter, I am appointing you an attorney, and I am setting hearings on May 28th at 8:30 in the downtown Maricopa County Superior Court. I'm also setting a secured appearance bond in your probation case in the amount of $7,500. In the event you are able to post your bonds and secure your release, I am reminding you, you are on probation, so you would need to contact your probation officer within 72 hours of your release. You'd also need to go to your hearings. If you are still in custody on the dates of your hearings, you will be transported for those hearings. All right, go ahead, step to left. Officer has your paperwork. X-Ben Verduzco, please, and then Donovan Jackson. All right, sir, go ahead, state your name.
Exwan Betusco,
And Mr. Verduzco, what is your date of birth?
August 25th, 1994.
Thank you. All right, sir. You are here because the Maricopa County Superior Court issued warrants for your arrest based upon allegations that you violated terms 3, 5, 15A, and 15D of your probations in your cases CR 2020-116712 and CR 2025-146577. In both of those matters, I am appointing you an attorney, and in both of those matters, I am setting hearings on May 28th at 8:30 in the downtown Maricopa County Superior Court. In your 2020 probation case, I am setting a secured appearance bond in the amount of $1,500. In your 25 probation case, I am setting a secured appearance bond in the amount of $500. Now, in the event you are able to post your bonds and secure your release, I am reminding you, you are on probation, so you would need to contact your probation officer within 72 hours of your release. You'd also need to go to those hearings on the 28th. If you are still in custody on the 28th, you will be transported.
All right.
All right, go ahead, step to left. Donovan Jackson, please, and then Efren Castro. All right, Ms. Jackson, go ahead, state your names.
Donovan Miguel Jackson,
And Ms. Jackson, what is your date of birth?
October 6, 1994.
Thank you. All right, sir. You are here because Maricopa County Superior Court issued warrants for your arrest based upon allegations that you violated terms 3, 4, and 5 of your probation in your cases CR 2023-138273 and CR 2024-109907. In both of those matters, I am appointing you an attorney, and in both of those matters, I am setting hearings on May 28th at 8:30 in the downtown Maricopa County Superior Court. In your 23 matter, I am setting a secured appearance bond in the amount of $500. In your 24 matter, I am setting a secured appearance bond in the amount of $500. In the event you are able to post your bonds and secure your release, I am reminding you, you are on probation, so you would need to contact your probation officer within 72 hours of your release. You'd also need to go to those hearings on the 28th. If you are still in custody on the 28th, you will be transported for those hearings. All right, go ahead, step to left. Officer has your paperwork. Efren Castro, please, and then Justice Root. All right, Mr. Castro, go ahead, state your name.
Austin Castro,
And Mr. Castro, what is your date of birth?
062604.
All right, sir. You are here because the Maricopa County Superior Court issued warrants for your arrest based upon allegations that you violated terms 1, 3, and 5 of your probations in your cases CR 2025 130807 and CR 2026 106848. In both of those matters, I am appointing you an attorney, and in both of those matters, I am setting hearings on May 28th at 8:30 in the downtown Maricopa County Superior Court. In your 25 probation case, I am setting a secured appearance bond in the amount of $500. In your 26 probation case, I am setting a secured appearance bond in the amount of $100. In the event you are able to post those bonds and secure your release, I am reminding you, you are on probation, so you would need to contact your probation officer within 72 hours of your release. You'd also need to go to those hearings on the 28th. If you are still in custody on the 28th, you will be transported for those hearings. All right, go ahead, step to the left. The officer has your paperwork. All right, Justice Root, please, and then Caitlin Havlin. All right, sir, go ahead, state your name.
Justice Root,
And Mr. Root, what is your date of birth?
May 22nd, 2000.
Thank you. All right, sir. You are here because the Maricopa County Superior Court issued a warrant for your arrest based upon your failure to appear in your probation case CR 2025 113562. In that matter, the court should already have made a determination about whether or not you are entitled to have an attorney appointed for you. So I'm not making that decision again this morning. I am setting hearings on May 28th at 8:30 in the downtown Maricopa County Superior Court. I'm also setting a secured appearance bond in your matter in the amount of $500. Now, in the event you are able to post that bond and secure your release, you would need to contact your probation officer within 72 hours of your release. Also need to go to those hearings on the 28th. If you are still in custody on the 28th, you will be transported for those hearings. All right, go ahead, step left. Caitlin Havlin, please, and then Christopher Lewis. All right, go ahead, state your name.
It's Caitlin.
And Caitlin, what is your last name?
Caitlin, her, Caitlin, Drew Havlin, Caitlin, her.
Okay. All right, Ms. Havlin, what is your date of birth?
June 23rd, 1985.
Thank you. All right. You are here because the Maricopa County Superior Court issued a warrant for your arrest based upon allegations that you violated terms 3, 4, and 5 of your probation in your case CR 2021-000662. In that matter, I am appointing you an attorney, and I am setting hearings on May 28th at 8:30 in the downtown Maricopa County Superior Court. Also setting a secured appearance bond in your matter in the amount of $250. In the event you are able to post that bond and secure your release, I am reminding you, you are on probation, so you would need to contact your probation officer within 72 hours. Also need to go to those hearings on the 28th. If you are still in custody on the 28th, you will be transported. All right. Go. Yes. All right, Christopher Lewis, please, and then Henry Acosta. All right, Mr. Lewis, go ahead, state your name.
Christopher Lewis,
And Mr. Lewis, what is your date of birth?
9/20/82.
Thank you. All right, sir. You are here because you were, you were here on a Superior Court new case. You were arrested yesterday on charges of 2 counts of aggravated DUI, passenger under 15, a class 6 felony, 1 count of endangerment, a class 6 felony, and 1 count of interfering with judicial proceedings, a class 1 misdemeanor. I did find probable cause for all of those. I am appointing you an attorney. I am setting hearings on June 5th at 8:30 and June 9th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. Will you go to those?
Yes, ma'am.
All right, then based upon your promise to appear, I'm going to go ahead and release you today to the supervision of pretrial services. Pretrial services will do things like remind you of your upcoming hearing dates. In your case, they are also going to do alcohol and drug testing. Sonia, can we reprint that? All right, you're not to consume any drugs without a valid prescription. You're not to possess or consume any alcohol. You're also not to possess or consume any marijuana, THC, or CBD products without a valid prescription. All right, go ahead, have a seat. We'll get that brought out to you, okay?
Thank you, ma'am.
Oh, and you're also not to drive a motor vehicle with anyone under 18 years old in that car, okay? Henry Acosta, please, and then Mario Chacon. All right, sir, go ahead, state your name.
Henry Acosta,
And Mr. Acosta, what is your date of birth?
10/16/1975.
Thank you. All right, sir, you are here on a Superior Court new case. You were arrested yesterday on charges of possession of dangerous drugs, a class 4 felony, and possession of drug paraphernalia, a class 6 felony. I did find probable cause for both of those. I am appointing you an attorney. I am setting hearings on June 5th at 8:30 and June 9th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. Will you go to those?
Yes.
All right, then based upon your promise to appear, I'm going to go ahead and release you today to the supervision of pretrial services. Pretrial services will do things like remind you of your upcoming hearing dates, okay?
Okay.
All right, you do need to go to those hearing dates. If you don't go, warrants may issue for your arrest, okay?
Okay.
All right, go ahead, step to left. Mario Chacon, please, and then Miguel Silvero Ocampo. All right, sir, go ahead, state your name.
Mario Ignacio Chacon,
And Mr. Chacon, what is your date of birth?
October 15th, 1993.
Thank you. All right, sir. You are here because you were arrested yesterday on charges of theft or control of stolen property, a class 6 felony. I did find probable cause for that. You were also arrested on charges of possession of narcotic drugs, a class 4 felony. Based on the limited information that I have in front of me this morning, I'm not finding probable cause for that drug violation. However, I'm letting you know that that drug violation is not dismissed and formal charges may nevertheless be filed for it. As I stated, I did find probable cause for that theft. In your matter, I am appointing you an attorney, and I am setting hearings on June 5th at 8:30 and June 9th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. Will you go to those?
Yes, ma'am.
All right, then based upon your promise to appear, I'm going to go ahead and release you today to the supervision of pretrial services. Pretrial services will do things like remind you of your upcoming hearing dates, okay?
Thank you.
All right, go ahead, step to left. Miguel Silvero Ocampo, please, and then Anthony Renfro. All right, Mr. Ocampo, go ahead, state your name.
Miguel Ángel Silverio Campo, 6/26/88.
Thank you. All right, sir. You are here because the Manistee Justice Court issued a warrant for your arrest. This is a failure to appear warrant. It was issued on March 9th of 23, involving charges from 22 of driving with a suspended or revoked license. In that matter, you're not entitled to have me appoint an attorney for you this morning. However, you may, of course, retain an attorney at your own expense to represent you. I am setting a hearing on June 10th at 10:30 in the Manistee Justice Court. Will you go to that?
Yes, ma'am.
All right, then based on your promise to appear, I'm going to go ahead and release you this morning on your own recognizance. You do need to go to that hearing. If you don't go to that hearing, a warrant may issue for your arrest, okay?
Yes, ma'am.
All right, go ahead, step left.
Thank you.
Anthony Renfro, please, and then Kirian Martinez.
Oh,
Hi. All right, Mr. Renfro, go ahead, state your name.
Anthony Renfro,
And Mr. Renfro, what is your date of birth?
12/10/76.
Thank you. All right, I'm going to ask you a question based upon your striped top. I'm going to talk to you about a West Mesa Justice Court matter. Are you in custody on a different matter as well?
Oh, yeah, I was.
Okay.
I was.
Hold on. Let me...
Oh, you talking about right now? Am I? Because, you know, I came in with a shirt, no shirt. So, yeah, they put me on this.
Okay, but I see you have a bracelet too. Is he in custody just on this Justice Court matter, or is there something else that's holding him here?
Got these matters, and it's got a justice court. Okay.
Oh, yeah.
Yeah, he's coming for that.
Oh, okay. So he's
Yeah,
here.
medical thing.
Okay.
Yeah.
Hold on then.
That was a medical part.
Oh, okay. Give me just a second. Okay. And I did update that. Okay. All right, sir. You are here. And you told me your date of birth was December 10th of 76, right? Okay. You are here because the West Mesa Justice Court issued a warrant for your arrest. This is a new complaint issue. And based upon allegations that on or about April 2nd of 26, you committed the offense of failure to comply with police officer class 2 misdemeanor and registration or license plate violation a class 2 misdemeanor.
Amen.
In that matter, I am appointing you an attorney for limited representation regarding the bond issue only, because I am setting a $50 secured appearance bond in that matter.
Okay.
I'm also setting a hearing on May 28th at 8:30 in the West Mesa Justice Court. Now, in the event you are still in custody on the 28th, detention officers should be able to arrange for you to attend that hearing remotely so you won't miss it, okay?
Okay, is there any way that I could just get OR'd on that? And if I am still in custody, I mean, I could just be released right now?
So you are, your officer is telling me that you're in custody on other charges?
If I was OR'd on the Mesa, I'll be all right. So I would just leave up out of here.
So if that's what you want, I'm happy to do that.
So-
My intention with the $50 secured appearance bond was to give you credit for time in custody.
I understand. If we just OR'd, I'll just
Okay.
walk out of here.
Fair enough. All right, and we'll change it back. Officer, do you still have the original set of papers?
No.
Okay, sorry about that. Give me just a second then. Okay,
Thank you.
that's not a problem. Okay, all right, that should be good. Sorry to go back and forth on that one. All right, sir, if you want to go ahead and have a
Thank
seat,
you.
we'll get that brought right out to you. All right, Kirian Martinez, please, and then Cedric Watkins. All right, sir, go ahead, state your name.
Morning, my name is Kerry Martinez. Date of birth December 15, 2001.
Thank you. All right, sir, you are here because, well, on a justice court new case, you were arrested yesterday on charges of reckless driving, a class 2 misdemeanor. I did find probable cause for that. You are also arrested on charges of driving with a suspended or revoked license, a misdemeanor. Based upon the limited information that I have in front of me this morning, I'm not finding probable cause for that, mostly because I looked at the Form 4 and it didn't say anything about your license status. So, however, I am letting you know that that charge is not dismissed and formal charges may nevertheless be filed for it. All right, based on the nature of your charges, you're not entitled to have me appoint an attorney for you this morning. However, you may, of course, retain an attorney to represent you at your own expense. I am setting a hearing on June 10th at 9 a.m. in the East Mesa Justice Court. Will you go to that?
I will.
All right, then based upon your promise to appear, I'm going to go ahead and release you this morning on your own recognizance. You do need to go to that hearing. If you don't go to that hearing, a warrant may issue for your arrest, okay?
Okay.
All right, go ahead, step to the left. Officer has your paperwork. Cedric Watkins, please, and then Rashad Timmons.
How you doing?
I'm all right. All right, sir, go ahead and state your name.
Cedric Watkins,
And Mr. Watkins, what is your date of birth?
8/31/2004.
Thank you. All right, sir. You are here on a Justice Court new case. You were arrested yesterday on charges of driving with a suspended or revoked license, a Class 1 misdemeanor. I did find probable cause for that. Based on the nature of that charge, you're not entitled to have me appoint an attorney for you this morning. However, you may, of course, retain an attorney at your own expense to represent you. I am setting a hearing on June 9th at 1:30 in the West McDowell Justice Court. Will you go to that?
Yes, ma'am.
All right, then based upon your promise to appear, I'm releasing you in that matter on your own recognizance. Now, you are also here because the Goodyear Municipal Court issued a warrant for your arrest. This is a post-adjudication failure to pay warrant, and it was issued on May 18th of 26. The underlying charge here is exceeding the speed limit by 20 to 45 miles per hour with an offense date of December 25.
Mhm.
In this matter, you're not entitled to have me appoint an attorney for you this morning. However, again, you may always retain an attorney at your own expense to represent you. I am setting a hearing on June 10th at 1 p.m. in the Goodyear Municipal Court. Will you go to that?
Yes, ma'am.
All right, then based upon your promise to appear, I'm releasing you in this matter on your own recognizance as well. Now, you do need to go to your hearings because if you don't go to your hearings, warrants may issue for your arrest, and you need not to drive a car without a valid license.
Yes, ma'am.
All right, don't come back and see us.
Oh, you won't see me. All right, appreciate it. Thank you.
Rashad Timmons, please. All right, Mr. Timmons, go ahead, state your name.
Rashad Timmons,
And Mr. Timmons, what is your date of birth?
6/30/90.
Thank you, sir. All right, sir, you are here on a Justice Court new case. You were arrested yesterday on charges of 3 counts of obstruction, refusing to give true name, Class 2 misdemeanors. I did find probable cause for those. In this matter, you're not entitled to have me appoint an attorney for you this morning. However, you may, of course, retain an attorney at your own expense to represent you. I am setting a hearing on June 11th at 9:30 in the El Centro Justice Court. Will you go to that?
Yeah.
Mr. Timmons, will you go to that?
Yeah.
Okay, then based upon your promise to appear, I'm going to go ahead and release you this morning on your own recognizance. You do need to go to that hearing. If you don't go to that hearing, a warrant may issue for your arrest, okay?
All right.
All right, go ahead, step to the left. Officer has your paperwork. Oh. I got confused. All right. Interpreter, this is Commissioner Campbell. Can you hear me okay?
There is a little bit of interference, but I think I can understand you. Is the person you want to speak with there with you?
We're about to call him up.
Oh.
All right, Kevin Alejandro Barrera, please.
Sure. Let me just. What is
Hola,
the
buenos
number
días.
you want me to dial out? Oh,
Kevin
it's here.
Alejandro.
Hola, hola,
Hola.
seré su intérprete en esta llamada. Hola, seré su intérprete en español en esta llamada. I'm ready for your instructions.
All right. Mr. Barrera, will you please state your name?
Señor Barbera, ¿puede por favor decirme su nombre?
Kevin Alejandro Barrera Muñoz.
Kevin Alejandro Barrera Muñoz.
Sí.
And Mr. Barrera Munoz, what is your date of birth?
Y señor Barbera Muñoz, ¿cuál es su fecha de nacimiento?
05/23/2001.
All right, sir. You are here on 2 Justice Court warrants.
Usted está aquí en Corte de Justicia 1.
Okay.
Sí.
So, we're going to go warrant by warrant, okay?
Vamos a ir palabra por palabra, ¿de acuerdo?
Okay.
All right. Your first warrant was issued by the El Centro Justice Court. This is a predisposition failure to appear warrant.
Predisposition failure to?
Predisposition failure to appear warrant.
Appeal warrant, thank you. Entonces, la primera fue la predisposición con fallo a la apelación 1.
This case involves an April 2023 charge of DUI.
Es el cargo de abril del 2023 por conducir bajo los efectos de alcohol.
Based upon the information that you provided to pretrial services, I am finding that you are not indigent for purposes of appointing you an attorney, so I'm not appointing you an attorney this morning. You may, of course, retain an attorney at your own expense to represent you.
Basado en lo que usted le brindó a los servicios, no tiene opción de tener un abogado, tiene que tener su propio abogado bajo su propio costo.
I am setting a hearing on May 28th at 8:30 in the El Centro Justice Court.
May 20 at 8?
May 28th, ma'am.
May 28 at 8:30, right?
May 28th at 8:30 in the El Centro Justice Court.
Just a moment. Entonces, usted va a tener su juicio en mayo 28 a las 8:30 de la mañana en la Corte Central de Justicia.
I am also setting a secured appearance bond in the amount of $250.
I'm sorry, a secure fine, you said?
I'm also setting
Hello?
a secured appearance bond in the amount of $250.
Thank you. También entonces vamos a tener un fondo asegurado de $250 por correo.
Okay.
All right. Now, sir, you are also here because the Tolleson Municipal Court issued a warrant for your arrest based upon your failure to appear in their matter.
Come again, please. Hello?
Hi. Okay, you are also here because the Tolleson Municipal Court issued a warrant for your arrest based upon your failure to appear in their matter.
Thank you. Y estamos aquí también porque la Corte de Tolosi tiene una orden porque usted falló en aparecer.
That matter involves a 2024 charge of DUI.
Esto involucra el cargo del 2024 por conducir bajo los efectos de alcohol.
In that matter, as with the previous, based upon the information that you provided to pretrial services, I am finding that you are not indigent for purposes of appointing you an attorney. So I'm not appointing you an attorney this morning.
Basado en esto, entonces la información que usted brindó en prejuicio, usted no tiene acceso a un abogado, entonces no le voy a dar un abogado.
You may, of course, retain an attorney at your own expense to represent you.
por supuesto usted puede tener un abogado, pero tendría que costearlo usted.
Okay.
I am setting a hearing on June 1st at 8:30 in the Tolleson Municipal Court.
Entonces, para junio 1 a las 8:30 usted va a tener una cita en Tolleson, en la corte de Tolleson.
Okay.
I'm also setting a secured appearance bond in the amount of $250.
También va a tener otro fondo asegurado de $250.
Okay.
In the event you are able to post your bonds and secure your release, you do need to go to your hearing.
Para que entonces usted pueda asegurar esos fondos y liberarlos, usted tiene que ir a la corte.
Okay.
If you don't go to your hearings, warrants may issue for your arrest.
Si usted no va a la corte, entonces se le puede mandar una orden de aprehensión.
You are not to possess or consume any drugs without a valid prescription, and you're not to possess or consume any alcohol.
Usted no puede consumir ni poseer ninguna droga ni alcohol sin prescripción, sin receta.
Okay.
All right, go ahead, step to the left. Officer has your paperwork.
Adelante, eche un vistazo al papeleo.
Okay. Gracias. Thank you.
All right, interpreter, thank you so much for your assistance this morning. We really appreciated it.
You're very welcome. Can I do something else for you?
Nope, we only had that one Spanish language matter.
Perfect. Thank you for calling Lionbridge. Interpreter 5912, disconnecting now.
All right, we do have two house calls this morning. Our first house call is Charlie Carlisle. Mr. Carlisle is unable to be with us this morning because he is being aggressive towards staff. His date of birth is February 2nd of 1991. As a result, I will conduct his IA at his cell. Mr. Carlisle is here because Maricopa County Superior Court issued a warrant for his arrest based upon his failure to appear in his matter. Involving possession of dangerous drugs, a class 4 felony, and possession of drug paraphernalia, a class 6 felony. In that matter, the court should already have made a determination about whether or not he is entitled to have an attorney appointed for him, so I'm not making that decision again this morning. I am setting hearings on May 29th at 8:30 and June 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. In his matter, I am setting a secured appearance bond in the amount of $1,000. Now, our other house call was Sarah McGlinchey. Ms. McGlinchey's date of birth is October 22nd of 1983. Ms. McGlinchey is currently in LBJ, and I spoke with her and conducted her initial appearance hearing immediately prior to court this evening or this morning. She is here because the Santan Justice Court issued a warrant for her arrest. Because the Santan Justice Court issued a warrant for her arrest. It's post-adjudication failure to pay warrant in her matter arising out of an April 2024 charge of assault. In that matter, I let Ms. McGlinty know that I was appointing an attorney to represent her for limited representation regarding the bond issue, only because I am setting a $50 secured appearance bond in her matter. I also informed her of her hearing date, which is May 28th at 8:30 in the Santan Justice Court. All right, if anything changes, although I've already conducted Ms. McGlinty's IA, if anything changes after I talk to Mr. Carlisle in-house, I will update his written order. All right, and that does bring us to Melissa Kelly. Come on up, Ms. Kelly.
Good morning, Judge.
Good morning.
How you doing?
I'm all right. All right, go ahead, state your name. Can you state your name?
Melissa Marie Kelly.
All right, are you hard of hearing?
Yes, I am, hon.
Okay, so we have headphones that can help with that. So
Okay.
let's get those. All right, I'm going to talk just so you, okay. All right, ma'am, go ahead, state your name.
Melissa Marie Kelly. Oh, wow.
Oh, yeah, so there's a dial, so you can turn it down or turn it up so that it works for you. Okay.
Is this my voice is real loud?
Okay. All right, ma'am. What is your date of birth?
12/18/52.
Thank you. All right. You are here because the grand jury in Maricopa County issued a warrant for your arrest based upon allegations that on or about August 27th, 24, you failed to register as a sex offender, a class 4 felony. In that matter, I am appointing you an attorney, and I am setting an arraignment hearing on May 29th at 8:30. Will you go to that?
Ma'am, I'm going to do everything you want me to do.
Okay. Then based upon your promise to appear, I'm going to release you today to pretrial services. Pretrial services will do things like remind you of your upcoming hearing date. In your case, they're also going to do electronic monitoring, okay?
That's fine.
Okay.
Do I have to pay for that?
No.
Good.
Basic release conditions, you're not to possess any weapons, no drugs without a valid prescription, don't drive a vehicle without a driver's license, and notify the court of any new address, okay?
Oh, sure.
All right, go ahead, step to the left, officer has your paperwork.
Okay. Thank you.
Thank you, sir. Or ma'am, sorry.
Ma'am, I get it all the time. Yes, thank you. So, I'm good to go.
Well, so you want to put your hearing things back on?
So, I have a job and I want to keep my job. So I'm active in the community. So
okay.
I'm not doing the wrong thing. I'm trying to do the right thing.
Okay. So I have ordered electronic monitoring. The electronic monitoring folks get in at 10 a.m. So you will have to wait for them.
And to hear?
Yeah.
Okay.
But once they get here and you get that ankle monitor put on, at that point you should be, again, I don't know, a detention officer probably has a better idea, but I would imagine you should be out by around noon.
Oh, that's fine, because my job is at 3 o'clock.
Okay.
So I get home just in time.
That's just my guess and my estimate, just to give you an idea.
Okay.
All right, go ahead, step to left, officer has you, or they already have your paperwork.
Appreciate it.
Mm-hmm. All right, that does in fact bring us to the end of our 2 a.m. initial appearance calendar. And we are going to go ahead, stand adjourned till 5, and we are off the record.
Just about to come in, we say all right. All right.
Thank you. May be seated. All right. Good morning. My name is Commissioner Elizabeth Campbell, and this is the 5 a.m. initial appearance calendar for May 22nd, 2026. The court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. Persons appearing before this court are reminded that they have the right to remain silent and that anything they say could be used against them. Most of you have qualified for a court-appointed attorney. If you have not qualified for a court-appointed attorney, or even if you have, you may retain an attorney at your own expense to represent you. I will be calling you up individually. When your name is called, please proceed to the podium. At the conclusion of your matter, officers will have paperwork for you. That paperwork will contain my complete orders in your case. It will also contain the dates, times, and locations of your future hearings. All right, I now need to read a victim's rights advisement. If you are the victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. All right. All right, we are going to go ahead and start with Fabian Ojeda Gonzalez, please, and then Edgar Granados. That is oh, I don't think so. Counsel, I was gonna take your matter last, if that's. Oh, I can go first or last. It's up to you. Because of the nature of the charges, or at least one of those charges, yeah. I was going to move him last. Thank you for letting me know. Okay. And I understand that. I appreciate it. All right, sir. Go ahead, state your name.
Fabian Gonzalez.
And Mr. Gonzalez, what is your date of birth?
November 1981.
Thank you. All right, sir. You are here because the Maricopa County Superior Court issued a warrant for your arrest based upon allegations that you violated terms 3. Hold on. I have a typo. Huh. No, I'm sorry. Can we reprint that? Based on allegations that you violated terms 3, 4, 7, 14, and 15 of your probation in your case CR 2020-020308. In that matter, I am appointing you an attorney, and I am setting hearings on May 28th at 8:30 in the downtown Maricopa County Superior Court. Pursuant to that probation violation arrest warrant, I am holding you non-bondable in this matter. All right, go ahead, have a seat. We'll get it brought out to you, okay? Thank you. Edgar Granados, please, and then Anthony Hamaloa. All right, Mr. Granados, go ahead, state your name.
Edgar Granados,
And Mr. Granados, what is your date of birth?
February 8, 2000.
Thank you. All right, sir. You are here on a Superior Court new case. You were arrested on charges of drive-by shooting, a Class 2 felony, 2 counts of aggravated assault, Class 3 felonies, 1 count of discharge of a firearm in city limits, a Class 6 felony, 2 counts of disorderly conduct involving weapons or dangerous instruments, a Class 6 felony, and 1 count of knowingly displaying a false license plate. That's a Class 2 misdemeanor. I did find probable cause for all of those. I am appointing you an attorney. I am setting hearings on May 29th at 8:30 and June 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. In your matter, I am setting a secured appearance bond in the amount of $150,000. In the event you are able to post that bond and secure your release, you would be subject to certain pretrial release conditions, including electronic monitoring. You're not to return to the scene of the alleged crime or have any contact with any alleged victim, complainant, or witness. You're not to possess any weapons, no drugs without a valid prescription, no alcohol. You are not to consume any marijuana, THC, or CBD products without a valid prescription. You're also not allowed to possess any simulated weapons. All right, go ahead, step to the left. Officers have your paperwork for you. All right, Anthony Hamaloa and then Mario Segundo. All right, sir, go ahead, state your name.
Anthony Lawrence Hamaloa, 10/19/2004.
Thank you. All right, sir, you are here because the grand jury in Maricopa County issued a warrant for your arrest based upon allegations that on or about June 12th, 2025, you committed the offense of unlawful flight from law enforcement, a Class 5 felony. In that matter, based upon the information that you provided to pretrial services, I am finding that you are not indigent for purposes of appointing you an attorney. So I'm not appointing you an attorney this morning. You may, of course, retain an attorney at your own expense to represent you. I am setting a hearing on May 29th at 8:30 in the downtown Maricopa County Superior Court. I'm also setting a secured appearance bond in your matter in the amount of $10,000. In the event you are able to post that bond and secure your release, you would need to go to your hearing on on May 29th at 8:30 in the downtown Maricopa County Superior Court. If you are still in custody on the 29th, you will be transported. All right, go ahead, step to the left. Officer has your paperwork. Mario Segundo, please, and then Lindley Hotchkiss. All right, sir, go ahead, state your name.
Mario Segundo,
And Mr. Segundo, what is your date of birth?
April 25th, 1966.
Thank you. All right, sir. You are here because Maricopa County Superior Court issued a warrant for your arrest based upon allegations that you violated terms 3, 7, 14, and 15 of your probation. In your case, CR 2018-121782. In that matter, I am appointing you an attorney, and I am setting hearings on May 28th at 8:30 in the downtown Maricopa County Superior Court. I'm also setting a secured appearance bond in the amount of $7,500. In the event you are able to post that bond and secure your release, I am reminding you, you are on intensive probation services, so you would need to contact your probation officer within 24 hours of your release. You'd also need to make sure that you go to that hearing on the 28th. If you are still in custody on the 28th, you will be transported. All right, we do need to reprint that because I had a typo, sorry. But if you go ahead, have a seat, we'll get that brought out to you, okay? All right, thank you. All right, Lindley Hotchkiss, please, and then Catherine Patton. All right, sir, go ahead, state your name.
Lindley Hotchkiss,
And Mr. Hotchkiss, what is your date of birth?
08/22/1982.
Thank you. All right, sir. You are here on 4 cases. We're going to talk about your pre-adjudication cases first, then we'll talk about your probation matters. All right, you are here because the Maricopa County Superior Court issued warrants for your arrest based upon your failures to appear in your matter, CR 2026-106405, which case deals with involves possession of narcotic drugs and possession of dangerous drugs, and another failure to appear warrant in your case, CR 2025-114604. This case deals with allegations of possession of dangerous drugs and possession of drug paraphernalia, as well as your cases CR 2021-129067. That's a probation case, and then a final failure to appear in your case CR 2021-114317, another probation case. In each of those matters, the court should already have made a determination about whether or not you are entitled to have an attorney appointed for you. So I'm not making that decision again this morning. In each of those cases, I am setting a hearing on May 29th at 8:30 in the downtown Maricopa County Superior Court. In each of those cases, I am setting a secured appearance bond of $2,500 in each case. So that is a total for all 4 cases of $10,000 in secured appearance bonds. In the event you are able to post those bonds and secure your release, I am reminding you, you are on probation, so you would need to contact your probation officer within 72 hours of your release. You'd also need to go to those hearings on the 29th. If you are still in custody on the 29th, you will be transported. All right, go ahead, step to the left. Officer has your paperwork. Catherine Patton, please, and then Francis Cowles. All right, Ms. Patton, go ahead, state your name.
Catherine Patton,
And Ms. Patton, what is your date of birth?
May 18th, 1979.
Thank you. All right, ma'am. You are here because give me just a second. I have been kicked out of my system. All right. I apologize. All right, ma'am. You are here because the Maricopa County Superior Court issued warrants for your arrest based upon your failures to appear in your matters CR 2025-107356. That matter involves forgery or offers forged, a violation of forgery or offers forged instruments, and CR 2025-123352. That case involves allegations of possession of dangerous drugs, possession of narcotic drugs, and possession of drug paraphernalia. In both of those cases, the court should already have made a determination about whether or not you are entitled to have an attorney appointed for you. So I'm not making that decision again this morning. In both of those cases, I am setting hearings on May 27th at 8:30 in the downtown Maricopa County Superior Court. In your 25 case ending 7356, that's the one with forgery offers forged instrument, I am setting a secured appearance bond in the amount of $1,000. In your 25 case ending 3352, that's the one with the possession of dangerous drugs, possession of narcotic drugs, and possession of drug paraphernalia charges. I am setting a secured appearance bond in the amount of $500. In the event you are able to post those bonds and secure your release, you do need to go to that hearing on the 27th. If you are still in custody on the 27th, you will be transported. All right, go ahead, step to the left. Officer has your paperwork. Francis Cowles, please, and then Steve Black. All right, go ahead, state your name, sir.
Francis Terrell Coles,
And Mr. Coles, what is your date of birth?
2/14/1986.
Thank you. All right, sir. You are here because the Maricopa County Superior Court issued a warrant for your arrest in a direct complaint matter. That direct complaint alleges that on or about March 7th of 26, you committed the offenses of possession or use of dangerous drugs, a Class 4 felony, and possession or use of drug paraphernalia, a Class 6 felony. In that matter, I am appointing you an attorney, and I am setting hearings on June 5th at 8:30 and June 9th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. Will you go to those?
Yes, ma'am.
All right, then based upon your promise to appear, I'm going to release you to the supervision of pretrial services. Pretrial services will do things like remind you of your upcoming hearing dates. All right, go ahead, step to the left. Officer has your paperwork.
Thank you, ma'am. Appreciate it.
Steve Black, please. And then Christopher Wayne Rostro. All right, Mr. Black, go ahead, state your name.
Steve Del Black,
And Mr. Black, what is your date of birth?
3368.
Thank you. All right, sir. You are here on a Superior Court new case. You were arrested yesterday on charges of possession of dangerous drugs, a Class 4 felony. I did find probable cause for that. I am appointing you an attorney. I am setting hearings on June 5th at 8:30 and June 9th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. Will you go to those?
Yes, ma'am.
All right, then based upon your promise to appear, I'm going to go ahead and release you this morning to the supervision of pretrial services. Pretrial services will do things like remind you of your upcoming hearing dates. You do need to go to those hearings on the 5th and the 9th. If you don't, warrants may issue for your arrest, okay?
Yes, ma'am.
All right, go ahead, step to the left, officer.
Hey, ma'am, on this, I know this is still Thursday, right?
So it is Friday.
Okay, because I have a court thing today in Glendale
Okay.
at 8:30 in the morning. I don't know.
So it will take them, again, you are getting released. It's going to take them a couple hours to process you out. Okay,
Okay.
go ahead, step to the left, officer has your paperwork.
Thank you.
Christopher Buenrostro, please, and then Lisa Mann.
Good morning, Your Honor.
Good morning, sir. Go ahead, state your name.
Christopher Buenrostro,
And Mr. Buenrostro, what is your date of birth?
May 24th, 1989.
Thank you. All right, sir. You are here on a justice court new case. You were arrested yesterday on charges of assault, causing fear of physical injury, a class 3 misdemeanor, and assault, touch to injure, a class 3 misdemeanor. I did find probable cause for both of those. Based on the nature of those charges, you're not entitled to have me appoint an attorney for you this morning. However, you may, of course, retain an attorney at your own expense to represent you. I am setting a hearing on June 9th at 9 a.m. in the Santan Justice Court. Will you go to that?
Yes, I will.
Okay, then based upon your promise to appear, I'm going to go ahead and release you this morning on your own recognizance. You're not to return to the scene of the alleged crime or have any contact with any alleged victim, complainant, or witness. You're not to possess or consume any drugs without a valid prescription. You're not to possess or consume any alcohol, and you're not to possess or consume any marijuana, THC, or CBD products without a valid prescription.
Okay.
All right. Go ahead, step to the left. Officer has your paperwork.
Thank you.
Lisa Mann, please, and then Mark Patton. All right, Ms. Mann, go ahead, state your name.
Lisa Mann.
And Ms. Mann, what is your date of birth?
1/22/82.
Thank you. All right, ma'am. You are here on a Superior Court new case. You were arrested yesterday on charges of organized retail theft, a class 4 felony, shoplifting, a class 1 misdemeanor, shoplifting removal of goods, a class 1 misdemeanor, and shoplifting concealment, a class 1 misdemeanor. I did find probable cause for all of those. I am appointing you an attorney. I am setting hearings on June 5th at 8:30 and June 9th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. Will you go to those?
Yes, ma'am.
All right, then based on your promise to appear, I'm going to release you this morning on your own recognizance. You do need to go to those hearings. If you don't go to those hearings, a warrant may issue for your arrest. You're not to return to the scene of the alleged crime or have any contact with any alleged victim, complainant, or witness.
Yes, ma'am.
All right, go ahead, step left, officer has your paperwork.
Please.
Mark Patton, please, and then Matthew McCullough. All right, sir, go ahead, state your name.
Mark Patton,
And Mr. Patton, what is your date of birth?
7/2/93.
Thank you. All right, sir. You are here on 3 municipal court warrants. So we're going to go warrant by warrant. You are here because the Peoria Municipal Court issued a warrant for your arrest. This is a pre-adjudication warrant in your matter involving failure to obey a police officer and possession of drug paraphernalia. And that is case CM 2025-000525. In that matter, you're not entitled to have me appoint an attorney for you this morning. However, you may, of course, retain an attorney at your own expense to represent you. I am setting a hearing on June 9th at 9 a.m. in the Peoria Municipal Court. Will you go to that? All right, then based on your promise to appear, I'm going to release you in that matter on your own recognizance. Now, you are also here because the Peoria Municipal Court issued a second warrant for your arrest. This one is in connection, again, with failure to obey a police officer, and this is your case CM 2026-000308. In this matter, you're also not entitled to have me appoint an attorney for you this morning. However, again, you may, of course, retain an attorney at your own expense to represent you. I am setting a hearing on June 9th at 9 a.m. in the Peoria Municipal Court. Will you go to that?
Yes.
And then based on your promise to appear, I'm going to release you in this matter as well. All right, finally, You are here because the Peoria Municipal Court issued a third warrant for your arrest. This one is in connection with your case involving possession of drug paraphernalia, and it is case CM 2025-000849. In that matter, again, you're not entitled to have me appoint an attorney for you this morning. However, again, you may, of course, retain an attorney at your own expense to represent you. Again, I am setting a hearing on June 9th at 9 a.m. in the Peoria Municipal Court. Will you go to that?
Yes.
All right, then again, based upon your promise to appear, I am going to release you in this matter on your own recognizance as well. Now, you do need to go to those hearings. If you don't go to those hearings, warrants may issue for your arrest, okay? All right, go ahead, step to the left. Officer has your paperwork. Matthew McCullough, please, and then David Kaiser. All right, sir, go ahead, state your name.
My name is Matthew McCullough,
Mr. McCullough, what is your date of birth?
10/26/2005.
All right, you are here because, you are here on a Superior Court new case. You were arrested on charges of theft, a Class 6 felony. I did find probable cause for that. I am appointing you an attorney. I am setting hearings on June 5th at 8:30 and June 9th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. Will you go to those?
Yes, ma'am.
And then based upon your promise to appear, I'm going to go ahead and release you this morning on your own recognizance. You do need to go to those hearings. If you don't go to those hearings, warrants may issue for your arrest. You're not to return to the scene of the alleged crime or have any contact with any alleged victim, complainant, or witness, okay?
Yes, ma'am.
All right, go ahead, step to the left.
Thank you.
David Kaiser, please. And then Christian Treviso. All right, Mr. Kaiser, go ahead, state your name.
David Kaiser,
And Mr. Kaiser, what is your date of birth?
3/23/78.
Thank you. All right, sir, you are here because the West Mesa Justice Court issued a warrant for your arrest based upon your failure to appear in their matter involving a April 25 charge of driving with a suspended or revoked license. In that matter, you're not entitled to have me appoint an attorney for you this morning. However, you may, of course, retain an attorney at your own expense to represent you. I am setting a hearing on June 9th at 8:30 in the West Mesa Justice Court. Will you go to that?
Yes.
Okay, then based upon your promise to appear, I'm going to go ahead and release you this morning on your own recognizance. You do need to go to that hearing. If you don't go to that hearing, a warrant may issue for your arrest, okay?
All right.
All right, go ahead, step to the left. Officer has your paperwork. All right, Christian Treviso, please. Did Ms. Fowler ever join? Okay. All right. No worries.
There's a lot of, long form 4, so, and it's all single spaced, and by the time I go through that, it takes a little while.
No problem. All right, Mr. Treviso, go ahead, state your name.
Christian Paul Treviso,
And Mr. Treviso, what is your date of birth?
7/9/87.
All right. And on behalf of Mr. Treviso this morning,
Vicki Lopez from Rosenstein Law Group.
thank you. All right, and Ms. Lopez, I'm just going to ask a clarifying question. And And it might be an answer that we said what we meant and we meant what we said, and that's fine. I see here that the notice of appearance you filed is for a limited notice of appearance for representation at this initial appearance only. Is that the case?
That is correct right now, as
Okay.
of right now. His family has not decided whether they want to proceed for this entire case
Okay.
or not. So Jen, I try to indicate when I know I'm going to be continuing on, but in this case, that was specific.
That is perfect. I just
Thank you for
I was going to
clarifying
update
that.
the council if you were going to continue with the case, but I will leave it as is for right now.
Right, because
Okay.
he will need a public defender if they decide not to retain.
Okay, perfect. All right.
I have a lot to tell you, so I don't know how you want to begin.
Okay, so here's how I usually do it. I usually break it up into, I break it up into two segments. One, probable cause,
Right.
and then once we talk about probable cause, then we will move on to terms and conditions of release. Okay? Okay. All right, sir, you are here on a Superior Court new case. You were arrested on 4 counts of possession of dangerous drugs for sale, class 2 felonies, 1 count of manufacture of dangerous drug, class 2 felony, 3 counts of transporting and or selling dangerous drugs, class 2 felonies, 1 count of possession of equipment for manufacturing dangerous drugs, a class 3 felony, 1 count of illegal control of an enterprise, a class 3 felony, 1 count of money laundering, a class 3 felony, 3 counts of use of electronic communications in a drug transaction, class 4 felonies, 1 count of possession of a weapon by a prohibited person, a class 4 felony, 1 count of possession or use of a weapon in a drug offense, a class 4 felony, and 1 count of child abuse, a class 4 felony. Now, based upon the information in the Form 4, I am inclined to find probable cause for those violations. However, I am going to hear argument from your counsel on probable cause if she would like to make any on probable cause.
Judge, the illegal control of an enterprise, the mere fact of selling drugs doesn't automatically mean it is a full-blown enterprise where he is controlling that. And there's been that and the money laundering, there's no evidence. I mean, the money involved in these 3 transactions totaled $750. So this is not a huge it's not an enterprise, it's not money laundering $750. There's no evidence of whether the money was ever laundered and not just spent. And spending it is not laundering it. And so I don't know that there is full probable cause for either there is no probable cause for either the illegal control or the money laundering. With respect to the child abuse, if you read the Form 4, I could see how you would think that there would be that there would be probable cause. That's part of what I want to talk to you about, because I think that it has to do with the contact with the child and with minors in general. First of all, he never did this when his child was home. And the substance that was found in the kitchen, they called it 2.5 gallons of liquid, was mimosa root like tea. It was just simply a base. It could be consumed just in its pure form. As it is, there was nothing illegal about it. It hadn't been used. It hadn't been converted to anything at that point. The brown substance that was in a pot in the kitchen, he keeps everything locked in his room. His child is never allowed to be in the room. On the way out the door, they were taking him to school that morning, and I think that the Form 4 indicates that he carried the pot that had the brown substance in it from his room, put it in the kitchen, and they left to go to school. If the child had not been going to school, he would never have done that. He does the garage that was being used for the rest of the manufacturing, again, only when the child was at school. Everything that was in that garage was moved into his room and locked before the child came home from school. And his brother actually resides at that house as well. His brother had no idea he was even doing this. And that's how careful that he was. And the gun was in a safe. And this is kind of interesting, because the use of a weapon during where'd it go? The gun part. Possession of a weapon and a drug offense. So technically, what he was doing in the house was the drug offense, and there was a gun in the house. He never ever possessed the gun in the sense, like he never carried it. It never left the safe ever. He didn't have it on him during any of these sales. It was just simply there. His brother was murdered. He had a mentally challenged, disabled brother, and the brother lived with their mother, but he would go to a daily school place. The caregiver at the school killed him, and it was murder. It was all over the paper back then. This was in 2018, and I don't know. Within a year or two after that, he was worried that the people that were involved, with this guy that killed his brother, knew where he lived, so he bought this gun, and being the prohibited possessor, there is probable cause he was a prohibited possessor, but that was why he did that, and the gun never left the safe, and the gun was locked in the safe, also for the protection, so that the child couldn't find it and haven't. And that's how family gun accidents often happen, when they're not locked away. And so he recognizes that he shouldn't have been doing this, but he protected his child through his child had no idea this was going on, had no idea anything was wrong. He never, and he was very, very careful. It was all, and I understand that the Form 4 would not show that, because when they entered the house, they waited until the child went to school, and this is what they found. So their presumption was that the child would have access to it. But that's not an accurate assumption, because he did not. And so that's where I would argue that there really isn't probable cause for the child abuse. And then that's all I have to say about probable cause.
Okay. And I appreciate that argument. However, based on the information in the Form 4, the drugs and the substances used to manufacture the drugs were in areas that were accessible to the child. The fact that there was a gun in the house where the drugs were being manufactured constitutes, in my opinion, possession or use of a weapon in a drug offense.
I anticipated that finding.
Okay. So, but again, this is just a probable cause finding. So based on the information in the Form 4, having heard counsel argument, I am going to find probable cause for all of those charges that I listed. I am, in view of counsel's, the information that counsel provided, I am going to go ahead and appoint you an attorney. And I am Maricopa County Public Defender, and I am setting hearings on May 29th at 8:30 and June 1st at 8:30. And counsel, we will, of course, feel free to take notes. However, we'll give you a courtesy copy on your way out, so you'll have it.
And just in case they do decide to retain us, then I would put that on my calendar. So, a status conference on May 29th at 8:30 and a preliminary hearing on June 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. I must now consider and decide terms and conditions of release. In order to do this, I have reviewed the Form 4. I have also reviewed the state's recommendation in this matter. The state is recommending a $150,000 secured appearance bond, along with terms of electronic monitoring and no contact with minors. I will hear argument, and no internet except for work, school, or school purposes. Counsel, have you seen the state's written recommendation? I did, except the only thing I couldn't, I read the things that she wanted checked. I just didn't see where she had asked for the $150,000. But I was curious as to why she hadn't put a monetary recommendation on here. So maybe it just didn't come. I just don't have it on the papers that I have. But I understand that, and I understand the basis for her recommendation, the boxes she checked asking for terms and her additional information. And I do need to address this.
Okay, yes, please.
All right. First of all, Judge, a $150,000 bond for this is excessive, unnecessary. this would be normally an OR case with an ankle, or with an ankle brace, with supervision on pretrial services. Yes, he was manufacturing it, but he will not be anymore while he's on release, and all of the things have been removed from his house. He certainly isn't going to initiate that again. He was not a danger to children. In general, he was not a danger to his own child, based on everything I told you. And then if they go back and look, they can find the gun was actually found in a locked safe. Again, for purposes of child safety, his lock on his room, and he would everything was moved from place where the child was not there and locked in his room. The child had to enter his room at any point in time, and he has custody of his child. The mother doesn't live in the state. The mother was deemed to be not a fit mother, and the child is extremely close with his father right now. The child is currently with grandma at grandma's house. And so there's a few things that I would ask. I think that he does have a job. His father is 90 years old, and his mother is younger than his father. So his mother is in her 70s and is caring for the child. His father is 90 years old. He also is in a wheelchair, and he is able, he is ill, and he owns an industrial park, 40 tenants, and his job, he manages the park. He manages the tenants. He does all the work. He also drives his father to doctor appointments and around. His mother helps too in that respect, but he does all these things in addition. This was something that he was doing that just an unbelievably poor choice to do all this with the situation, with the life situation that he had. So several things. I would like him to be able to return to the residence. That's a house that his mother owns, that his brother lives there, that's where he resides, and there's going to be nothing there for him. It's not like the scene of a crime in the sense of that he shouldn't return to the scene of the crime. They've already processed everything and removed everything. No contact with children is not necessary. This is not a sex case. He is not a danger to children. And the fact that his child was in the house, it was a poor choice to do what he was doing, but he took every possible measure he could to make sure that his child was not exposed to anything and that his child did not know what was going on. So the only child at issue in this case was his own child. So no contact with minors makes no sense. And I would like contact with his child. Even if, and I don't know if DCS, I didn't see in the Form 4 any mention of DCS, so I am assuming DCS was contacted, but maybe not. But either way, his mother has him because of him being arrested and being in custody. So, and DCS's normal process, if they are involved, is going to be to remove, if they deem it necessary, to remove him from and based on that Form 4, I would assume that they would take that at face value and not look further and take him out of the home. Then they look for a family member, so they don't have to make him a ward of the state. So that part, I think, is taken care of, and the child can continue to live there, but he does need to have contact with his child. It's also going to be devastating for the child not to have contact with him. And I don't believe, and if the court is concerned, see, that's the thing. This is not a child abuse case in the sense where he's beating him or starving him or doing something where if he had contact alone with him, that the child would be at risk. Even unsupervised contact is not going to be, the child is not at risk now. And so I think that's something to be considered. So I'm asking for contact with the child, okay, to return to the residence, to delete the no contact with children, to allow him contact with his own child, and under these, let me make sure I've got all of my, the history I wanted to tell you also, I think that's relevant to determining. He's on probation. This is not accurate in the Form 4. He is on probation for a possession of drug paraphernalia as a Class 6 undesignated offense. It's a Prop 200 case, and he was given diversion in that case, which he did not successfully complete. They reinstated the prosecution and gave him a 6 open and gave him supervised probation. And so in other words, there's no reason in that case, he can be held non-bondable in light of the Prop 200 nature of the case. And so, because I know that can be an issue now, the way with certain initial release conditions on probation violation matters. And the DUI is a misdemeanor, and it says, in the Form 4, it says, on probation with MCSO for a DUI. Two things. That doesn't make sense because you're not on probation with MCSO. And second thing is, what it is he was on misdemeanor unsupervised probation out of Mesa Municipal Court for misdemeanor DUI. The DUI and the narcotic drugs that were in the underlying drugs on the felony all had the same data violation. So when he was caught for the DUI, he was in possession of the drugs. They bifurcated the charges, the felonies over to Superior Court and the DUI to the misdemeanor court. And his other prior was from 2015. It was a possession of narcotic drugs for sale. He successfully completed his probation August 16th of 2018. And he did not, his co-defendant ended up being revoked to prison. He did not have any violations, and his order of discharge from probation. So, I mean, I know when you read the state's recommendation in her little summary, it makes it sound like, he's on probation, which is true, but it is a Prop 200 case, and I think that's relevant. But everything I've told you about the danger to the child, about the fact he's responsible for the child, he took that seriously. I mean, there's a lot of people that do what he's doing that don't take these precautions, whose kids know what's going on, whose kids are exposed, and none of this ever happened while the child was at home, and everything was locked away when the child was at home. So, Your Honor, I think that everything I'm asking for, and plus, if you want to set a bond, the bond, I don't know why there's a $150,000 bond would even be deemed necessary in this case. The last big drug sale case I had, they set a $150,000 bond in that case, and the state agreed that that was excessive and recommended conversion to a $10,000 secured appearance bond, and the court ended up releasing him OR with an ankle bracelet during my modification hearing.
Are we done?
Not yet. What do you?
It's in regard to my son, but when you're done.
Okay, yes, you can. He would like to tell you something about his son, but in just a second. So anyway, if there needs to be a bond, I would ask that it be like less than $10,000. It's just, the purpose of a bond is to make sure he's not a danger to society. By the way, that's another thing. I mean, all of this went on selling drugs does not make him a danger to society. I mean, it's bad to sell drugs to people who want them in the community, but it doesn't mean that he's endangering society by being a drug seller. And there's a lot of different nuances there. And and the fact that he is not going to fail to appear for court. He is more concerned with having his son and being around his son, and running is not in his, is something he would not do. So the bond is actually not necessary. So, and he would like to tell you something about his son.
Okay. And counsel, will you remind your client that this is public and it is being recorded, so we're not using names, especially for minors?
Okay.
In regards to my son, Your Honor, I understand what the charges against me look at and what it may seem on paper. I keep my son in sports, 2 sports at all times, soccer, basketball right now. So, I mean, everything I do is around my son. That's 4 days out of the week. As soon as I get out of work, I got to go and take him to a sport or a game. My life is around my son. The decisions I made, albeit we're poor, I try to do it in the safest instance, but it was a dumb mistake, and I fully understand the seriousness of my actions and what's going on here today. But I took very well care of my son, and his mom is not in the picture, and I just know it would devastate him deeply if I was to not allowed to have contact with him. But I just wanted to say that my son is my priority, and everything I did was for him. As far as like my day to day was about him. It was work for my son. That's all it was.
Okay. I appreciate the information. I appreciate the argument, counsel. All right. And I do understand that Mr. Treviso has significant ties to the community, particularly his family. That being said, running a drug production out of your house is certainly something that I would consider to be a danger to the community, and I am going to go ahead and set a bond. I'm going to go ahead and set a secured appearance bond in the amount of $100,000. In the event he is able to post that bond and secure his release, he would be subject to certain pretrial release conditions, including electronic monitoring. He is prohibited from accessing the internet except for school, work, and court purposes. He's not to possess any weapons, no drugs without a valid prescription, no alcohol. He's not to possess or consume any marijuana, THC, or CBD products without a valid prescription. Now, he is on probation. So if he's able to post that bond and secure his release in counsel, I'm sure you would have informed him of this. He would need to contact his probation officer within 72 hours of his release. I'm not, in view of the fact that this is his residence, I'm not going to prohibit him from returning to the residence. I know the other big concern that you addressed was the contact with children. I am not putting in across the board, no contact with minors. Here's what I'm going to say. He may have contact with a minor victim only so long as that contact is supervised by DCS or an appropriate responsible adult.
Such as his mother.
Such as grandma.
Okay.
Okay?
Judge, the way we're doing this would make it so that he would be not able to, grandma would have to go with him to take him to practices, to take him to games, and do all of that. Is that?
Yeah, the contact needs to be supervised. Yeah.
Okay. Okay.
Now, I understand that you don't agree with me, and that's fine. You will have an opportunity. His next hearing is on May 29th at 8:30, and that is the status conference. And I'm sure you will be presenting argument at that hearing.
Yeah, we'll probably ask to revisit some of these issues. I have another question. Just a second. I just lost my train of thought, and I can't remember what it was. What? No. Oh no, that's what I asked for. So.
All right. If there is nothing further, did we get a copy of that printed? All right. Did we get counsel a courtesy copy? All right. All right. Then with that, we do need to move on because we do need. He's also been page 2'd on the probation.
Oh, that's what I was going to ask you, because that's what they told me. The clerk told me when I talked to him on the phone this morning, is that there was a page 2 for that.
Page 2.
Okay.
All right, sir. Now you are on probation in your case, CR 2024-132524. Your attorney referred to that. That is the one for possession of drug paraphernalia, I believe. In that matter, your new charges would constitute an alleged term 1 violation of your existing probation case. In your probation matter, I am appointing you an attorney, the public defender, and I am setting hearings on May 28th at 8:30 in the downtown Maricopa County Superior Court. Your probation matter, I am setting a secured appearance bond in the amount of $250.
Judge, I don't know that you can actually set a secured appearance bond on a Prop 200 case.
I can.
Okay, I can address, I know it's a very nominal amount, but I think that Prop 200, he's not allowed to go to prison on that.
Okay.
And so he's actually entitled to bond unless there's a finding in the probation case that there's a reasonable likelihood that he can be held non-bondable, but there's a likelihood that he can go to prison. But on a Prop 200 case, that's not a possibility or a likelihood, and therefore he usually must be released OR is what. And I would thought there's case law on that, but I know that is the actual physical practice as well. So.
And again, you will be talking to the judge in the probation matter, assuming you're retained on the 28th. I'm going to go ahead and leave that secured appearance bond set in the amount of $250 in this case. All right. If there is nothing else.
Okay. No, I don't think so.
Okay, that does in fact bring us to the end of our 5 a.m. initial appearance calendar, and we are going to go ahead and stand adjourned until 8 a.m. and we are off the record. Okay, could we print her, Chanel, could we print her that as well? And one for Mr. Treviso as well. If we didn't already. He already has one.
I can try to get it done again, or your longer can, the hearing, but, so. I don't know. Thank you. Okay. Thank you. You too. Okay. All right.
All right, and with that, I believe we really are off the record and we are going to stand adjourned until 8 a.m.
Speak to you for a minute.
Yes.
property?
Morning, this is a Spanish interpreter. All right, sounds good. Have a good one.
All right.
Thank you. You may be seated. Good morning. This is the time set for the 8 a.m. initial appearance calendar on May 22nd, 2026. The court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. I will call you each one at a time to the podium. I'll provide a second name to sit in the chair outside of this room. I will let you know what you are here for, if I have appointed an attorney, if you have a bond, and what your release conditions are. We will also go over the victim's rights advisement. If you are the victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. If we could start with Robert Kelton to the podium and Nicholas Benson to the chair. Good morning. May I get your name and date of birth?
Yeah, Robert Kelton, 6/20/88.
Thank you, sir. It does look like you are here today on a warrant from the Gila County Superior Court with allegations that you violated your probation. I am going to appoint an attorney. You're going to have an arraignment hearing May 28th at 8:30. That is in Gila County. They are holding you non-bondable, so you will remain in custody and be transported to that hearing.
Okay.
Did you have any questions?
Yeah, see, because, I was on probation here in Phoenix, and they are supposed to talk to my probation officer, and I haven't been violated by Phoenix yet. So if I haven't been violated by Phoenix yet, how am I violated by Gila County?
I don't have any information on your Gila County case. They just simply indicated that you violated your probation. To find out specifically, unfortunately, you will have to ask them as to what specifically they're violating you on. I don't have that information here today. We did contact them to confirm. They did indicate it was a valid warrant, and they did want to extradite you and take you to Gila County for that hearing. But again, as it relates to what they're alleging you violated, you'll have to take that up with the Gila County judge.
Okay.
Okay?
So when is that?
Your hearing is scheduled for May 28th. That's a little less than a week, 6 days from today.
Okay.
Okay? If you'll step to your left, the officer will get that for you. Nicholas Benson to the podium and Tristan Chambers to the chair. Can I get your name and date of birth?
Nicholas Benson, 6305.
Thank you, sir. You are here today on 2 cases. You're here today on a new case as well as your probation case. Your new charges are for 1 count of murder in the 1st degree, a class 1 felony, 1 count of murder in the 2nd degree, a class 1 felony, 1 count of manslaughter, class 2 felony, 1 count of aggravated assault involving a deadly weapon or dangerous instrument, class 3 felony, 1 count of possession of a weapon by a prohibited person, class 4 felony, and 1 count of disorderly conduct involving a weapon, a class 6 felony. And then because you were on probation at the time of this alleged offense, you're also here on a term 1 probation violation. I am finding probable cause and appointing an attorney to represent you in both cases. You're going to have 3 hearings coming up. It's going to start with a probation revocation hearing, May 28th at 8:30, a status conference, May 29th at 8:30, and a preliminary hearing, June 1st at 8:30. Those are all going to take place in our downtown Superior Courthouse. In your new charges, you have a cash bond of $1 million. In your probation case, it's $500,000. In the event you were to post that bond and be released from custody, you would be released to the supervision of pretrial services, and you'd be equipped with electronic monitoring. You also have written conditions of release. You're not to return to the scene of the alleged crime, no contact with any alleged victim or any next of kin related to the victim, no contact with any complainants or witnesses, and you must contact your probation officer within 72 hours of release. This will be in your paperwork. Did you have any questions?
No, ma'am.
Please take a step to your left and the officer will get that for you. Tristan Chambers to the podium. Pablo Maldonado to the chair. May I get your name and date of birth?
Tristan Chambers, 8/26/2000.
Thank you, sir. It does look like you are here today on 3 cases. It looks like you're here today on new charges as well as 2 probation violation warrants that were issued. Your new charges are for 1 count of aggravated assault, a class 6 felony, 1 count of theft, a class 1 misdemeanor, and 3 counts of dangerous drug possession, a class 4 felony. In your probation case, warrants issued alleging you violated terms 7, 11, 12, and 21. I am going to find probable cause on your new case. I am going to appoint an attorney to represent you in all 3 cases. You have 3 hearings coming up. You're going to have a probation revocation hearing, May 28th at 8:30, a status conference, May 29th at 8:30, and a preliminary hearing, June 1st at 8:30.
All right.
In your new case, you have a secured appearance bond of $25,000. In 1 probation case, you have a bond of $1,200. In the 2nd case, you have a bond of $250. So you have a total bond of $26,450. In the event you were to post that bond and be released from custody, you would have written conditions. You're not to return to the scene of the alleged crime, no contact with any alleged victims, no possessing weapons, and you must contact your probation officer within 72 hours of release. This will be in your paperwork, sir. Did you have any questions?
No.
Please take a step to your left and the officer will get that for you. Pablo Maldonado to the podium. Ricky Burse to the chair. May I get your name and date of birth?
Pablo Maldonado, August 22nd, 1997.
Thank you, sir. It does look like you are here today on two cases. You're here on a new case. You're also here because a warrant issued out of the Yavapai County Superior Court with allegations that you violated your probation. Your new charges are for 1 count of intent to facilitate shoplifting, a Class 4 felony, and 1 count of shoplifting removal of goods, a Class 1 misdemeanor. Probable cause has been found, and I'm appointing an attorney to represent you. In this case, you're going to have a status conference May 29th at 8:30 and a preliminary hearing June 1st at 8:30. That is going to take place in the Maricopa County Superior Court. Your second warrant comes from the Yavapai County Superior Court. Again, as I mentioned, it's allegations that you violated your probation in that case. I am going to appoint an attorney to represent you, and I'm going to set a hearing. But that hearing is actually going to take place in the Yavapai County Superior Court, May 28th at 8:30. In that case, you have a secured appearance bond of $25,000. In your new charges, I'm putting what's called a placeholder bond. It's a $50 bond. What that does, it just ensures that if you don't bond out of custody, it gets you credit for any time served, and it gets you transported for any hearings. But in the event you do post bond on the Yavapai County case, which is the $25,000, then you just post $50 on your Maricopa case, and you'll be released from both cases. But then it would be your responsibility to ensure that you got yourself to all of your hearings. And as I mentioned, some are here in Maricopa, some are here in Yavapai County. So you would have to get yourself to those hearings. If you fail to appear at any of those hearings, a warrant would issue for your arrest, and then you'd also forfeit any bond you posted. If you're unable to post the bond, you will be transported for your hearings. Did you have any questions?
So if I don't place bond, I stay here?
You'll remain in custody of Maricopa County, and then you'll eventually go to Yavapai County for your hearings there as well, okay? Any questions?
Nope.
Okay, just take a step to your left. The officer will get that for you. Ricky Burse to the podium. Shauna to the chair. May I get your name and date of birth?
Ricky Burse, 4/25/86.
Thank you, sir. It does look like you are here today on two cases. You're here on a new case as well as your probation case. Your new charges are for 2 counts of transporting narcotic drugs for sale, a Class 2 felony, 2 counts of possession of narcotic drugs for sale, a Class 2 felony, 1 count of transporting dangerous drugs for sale, a Class 2 felony, 1 count of possession of dangerous drugs for sale, a Class 2 felony, and 2 counts of using electronic communications during a drug transaction, a Class 4 felony. And then because you were on probation at the time of this offense, you're here, or this alleged offense, excuse me, you're here on a Term 1 probation violation. And finding probable cause and appointing an attorney to represent you in both cases, you have 3 hearings coming up. It's going to start with a probation revocation hearing, May 28th at 8:30, a status conference, May 29th at 8:30, and a preliminary hearing, June 1st at 8:30. Those are all going to be in the downtown Superior Courthouse. On your new charges, you have a secured appearance bond of $5,000. On your probation case, it's $1,000. That is a total bond of $6,000. In the event you were to post that bond and be released from custody, you would have written conditions. You're not to possess weapons or alcohol. You're not to possess or consume drugs without a valid prescription. And you must contact your probation officer within 72 hours of release. This will be in your paperwork, sir. Did you have any questions?
Yes, the bond, is that 10%?
It is secured, meaning you can use a bail bonding company. Bail bonding companies are typically 10% plus collateral, but I recommend contacting them to get their specific terms and conditions. If you'll step to your left, the officer will get that for you. Shauna to the podium and Amanda to the chair. May I get your name and date of birth?
Shauna McElrath, 9/29/99.
Thank you, ma'am. It does look like you are here today on 2 cases. You're here today on a new case as well as your probation case. Your new charges for 1 count of aggravated assault, a Class 6 felony, and 1 count of theft, a Class 1 misdemeanor. Because you were on probation at the time of this alleged offense, you're also here on a Term 1 probation violation. I am finding probable cause and appointing an attorney to represent you. You have 3 hearings coming up. You have a probation revocation hearing, May 28th at 8:30, a status conference, May 29th at 8:30, and a preliminary hearing, June 1st at 8:30. Those 3 hearings will take place in our downtown Superior Courthouse. You do have a secured appearance bond of $5,000 in your new charges. You have a secured appearance bond of $500 in your probation case. for a total bond of $5,500. In the event you post that bond and are released from custody, you have written conditions. You're not to return to the scene of the alleged crime, no contact with any victims. You're not to possess weapons or alcohol, and you must contact your probation officer within 72 hours of release. This will be included in your paperwork, ma'am. Did you have any questions?
No, thank you.
Please take a step to your left, and the officer will get that for you. Amanda Wynn to the podium, Connor Owens to the chair.
Mm.
May I get your name and date of birth?
Yes, ma'am. Amanda Wine, August 13th, 1983.
Thank you, ma'am. It does look like you are here today because a direct complaint was filed. This was filed on May 21st of 2026, so yesterday.
Mhm.
It does relate to an offense date of November 5th of 2025 for shoplifting, a class 4 felony. I'm going to appoint an attorney. I'm going to set a status conference, May 29th at 8:30, and a preliminary hearing, June 1st at 8:30. In this case, you do have a secured appearance bond of $2,500. Are you currently in custody on additional cases with bonds?
I think one, yes, ma'am.
Okay. So if you have a bond in the other case, this would be in addition to that. So you'd have to post both bonds to be released. But in the event you did that and were released, you'd have written conditions. It does include not returning to the scene of any alleged crime, not possessing weapons or alcohol, and contacting your probation officer within 72 hours. That will be in your paperwork, ma'am. Did you have any questions?
No, nothing besides the fact that you said it was secure.
It is a secured appearance bond, yes, ma'am.
Okay,
Okay?
that's it.
If you'll step to your left, the officer will get that for you.
Thank you.
Connor Owens to the podium. David Marlowe to the chair.
Can we go to David?
Yes. David Marlowe to the podium. Robert Anderson to the chair. May I get your name and date of birth?
David Marlowe, 8/18/84.
Thank you, sir. It does look like you are here today on two cases. You're here on a new case, as well as a failure to appear warrant that was issued for you. Your new charges are for 1 count of dangerous drug possession, a class 4 felony, and 1 count of drug paraphernalia possession, a class 6 felony. Your failure to appear warrant looks like you failed to appear at a hearing related to your probation case. I am finding probable cause on your new charges. I'm appointing an attorney to represent you. You're going to have 3 hearings coming up. You're going to have a probation hearing, May 28th at 8:30, a status conference, May 29th at 8:30, and a preliminary hearing, June 1st at 8:30. All of your hearings will take place in our downtown Superior Court. You have a $350 secured appearance bond on your failure to appear case related to your probation case. On your new charges, you have a placeholder bond of $50. So your bond between both cases is $400. In the event you post that bond and are released from custody, you have written conditions. You're not to possess any weapons. You're not to possess or consume any drugs without a valid prescription. And you must contact your probation officer within 72 hours of release. It's also going to be your responsibility to ensure that you would get to all of your hearings if you do post that bond. If you were to fail to appear, another warrant would issue, and then you'd forfeit any bond that you may have posted. That'll be in your paperwork, sir. Did you have any questions?
No, ma'am.
Please take a step to your left, and the officer will get that for you. Robert Anderson to the podium. Did we find Connor?
Yes. Yes.
Okay, and Connor Owens to the chair outside of this room. Can I get your name and date of birth?
Robert Anderson, 11083.
Thank you, sir. It does look like you are here today on a child support arrest warrant that was issued out of Gila County. Because this hearing is civil in nature, I cannot appoint an attorney to represent you, but you can hire one at your own expense if you would like. Your hearing is going to take place in Gila County on May 28th at 8:30 in the morning. Your hearing is a little bit different in the sense that you have a cash purge of $348. And what that means for you is you cannot use a bail bonding company.
Mhm.
If you post that, you also will not get it back. It will apply to any child support arrears or current child support obligation that you may owe.
Yes,
And if you post that, you will be released, but it will be your responsibility to get to that hearing in Gila County. And if you fail to appear, another warrant would issue with a new child support purge.
Yes, ma'am.
This will be in your paperwork. Did you have any questions?
No, ma'am.
Please take a step to your left, and the officer will get that for you.
Thank you.
Connor Owens to the podium. Carlos Coda to the chair. May I get your name and date of birth?
Connor Owens, June 15th, 1998.
Thank you, sir. You are here today on 2 probation violation warrants with allegations that you violated terms 3, 4, 6, and 7. I'm appointing an attorney and setting a probation revocation hearing May 28th at 8:30. You have a secured appearance bond of $250 in each case for a total bond of $500. In the event you post that bond and are released from custody, you have written conditions. You're not to possess weapons or alcohol, and you must contact your probation officer within 72 hours of release. This will be in your paperwork, sir. Did you have any questions?
No, thank you.
Please take a step to your left, and the officer will get that for you. Carlos Coda to the podium. Sarah Goodwin to the chair. May I get your name and date of birth?
Carlos Cueta, 2/17/1994.
Thank you, sir. You are here today on a probation violation warrant with allegations you violated terms 3 and 5 of your probation. I'm appointing an attorney and setting a probation revocation hearing May 28th at 8:30. You have a secured appearance bond in the amount of $250. In the event you post that bond and are released from custody, you do have written conditions. You may not possess weapons or alcohol, and you must contact your probation officer within 72 hours of release. This will be in your paperwork, sir. Did you have any questions?
No.
Please take a step to your left, and the officer will get that for you. Sarah Goodwin to the podium. Jonathan McLean to the chair. Good morning. May I get your name and date of birth?
Sarah Goodwin, 5279.
Thank you, ma'am. You're here today because a warrant was issued from the Santan Justice Court. It does look like it relates to an underlying offense of disobeying an order of the court, a Class 1 misdemeanor. It looks like you were also previously seen by this court on some different charges yesterday morning at 8 o'clock in the morning.
I wasn't seen, but I had been, yeah. I wasn't here. I was in a psych.
Oh, okay.
Yeah.
All right, but you were given orders from
Yes,
that?
ma'am.
Okay. So what I'm going to do in this case, I'm going to appoint an attorney. I'm going to set a hearing in the Santan Justice Court, May 28th at 8:30.
I was in the hospital why I missed the court date. That's why they gave me the bench warrant.
Okay, you were in the hospital at the
Yeah.
time you failed to appear at this hearing. Okay. Because you're in custody on other charges and you're being held on a bond, I'm going to place what's called a placeholder bond. It's a $50 bond. What that does is if you're unable to post all of your bonds and you remain in custody, it ensures that you get credit for any time served and that you also take into any hearings as it relates to the Santan Justice Court. However, if you're able to post the bonds on your other case, you post the $50 bond on this case, it gets you released. You have release conditions you need to comply with, and then it'd be your responsibility to get yourself to all of your hearings. The hearings you were given yesterday, plus this hearing, which will take place in Santan Justice Court. Some of your release conditions include not possessing any drugs without a valid prescription, not driving a motor vehicle without a valid driver's license, okay?
Don't do that anyway, yeah. Okay.
That'll be in your paperwork. Do you have a question?
Nobody will pay my bonds. I'm here till the next court date.
Okay, so then whatever hearing dates you were given yesterday, you'll be transported for, and then you'll be transported for this hearing as well, okay?
All right, thank
Just
you
at your
very much.
left, the officer will get that for you. Jonathan McLean to the podium. Christopher Steed to the chair. May I get your name and date of birth? May I get your name and date of birth?
Jonathan McLean, July 11th, 1975.
Thank you, sir. You're here today because a direct complaint was filed. It has an offense date of January 25th of 2026. It is for 2 counts of possession of a weapon by a prohibited person, a Class 4 felony, and 1 count of carrying a deadly weapon and failing to admit, a Class 1 misdemeanor. I'm appointing an attorney to represent you, and I'm going to set a couple hearings in the Superior Court. You're going to have a status conference June 5th at 8:30 and a preliminary hearing June 9th at 8:30.
Okay.
I am going to release you to the supervision of pretrial services. You have written conditions. You're not to possess any weapons, and you're not to possess or consume any drugs without a valid prescription. With your paperwork, you're going to get an envelope. You'll need to read the instructions and contact pretrial services within 72 hours of your release, and then you'll need to ensure that you attend all of your future hearings. If you fail to appear, a warrant would issue, and then you'd be held on bond at your next hearing. Did you have any questions, sir?
No, ma'am.
Okay, so step to your left. The officer will get
So
that for you.
I'll be leaving today.
It takes about 4 to 6 hours to be released, but if this is the only thing you're being held on, you'll be released today. All right,
Thank you.
thank you, sir. Christopher Steed to the podium. Santa Galvez to the chair. May I get your name and date of birth?
Christopher Steve, 418, or, yeah, 1979.
Thank you, sir. You're here today on 4 cases. You're here today on a new case, and then you're here on 3 probation cases. Your new charges are for 1 count of dangerous drug possession, a class 4 felony, and 1 count of narcotic drug possession, a class 4 felony. And because you were on probation in your 3 cases at the time of this alleged offense, you're here on 3 term 1 probation violations. I am finding probable cause and appointing an attorney to represent you in these cases. You're going to have a probation revocation hearing May 28th at 8:30, a status conference June 5th at 8:30, and a preliminary hearing June 9th at 8:30. I am going to release you today to the supervision of the Adult Probation Department, but you do have written conditions of release. You are not to possess any weapons. You are not to possess or consume any drugs without a valid prescription. You also must contact your probation officer within 72 hours of release, and then you'll also need to ensure you attend all of these future hearings. If you were to fail to appear at any of them, a warrant would issue for your arrest, and then you'd be held on bond at your next hearing. That will be in your paperwork, sir. Did you have any questions? Please take a step to your left, and the officer will get that for you. Santa Galvez to the podium. Marcus Milius to the chair. May I get your name and date of birth?
Santa Galvez, 9/14/82.
Thank you, ma'am. It does look like you are here today on 2 cases. You're here on a new case, and you're also here because a warrant was issued from the El Centro Justice Court. Your new charges are for 1 count of taking contraband into a correctional facility, a class 2 felony, and 1 count of dangerous drug possession, a class 4 felony. Probable cause has been found, and I'm going to appoint an attorney to represent you.
Thank you.
These 2 hearings are going to take place in the Superior Court. That's going to be a status conference June 5th at 8:30, and a preliminary hearing June 9th at 8:30. But you have a second case on the calendar, as I mentioned, from the El Centro Justice Court. That is for failing to appear at a hearing in 2025 with an underlying charge of driving with a license that was suspended, revoked, or canceled.
Oh, yeah.
In that case, you're not entitled to court-appointed counsel, but you can hire an attorney at your own expense if you would like. That hearing will take place in the El Centro Justice Court on June 11th at 8:30. So you have 3 hearings coming up. They are in 2 different locations. Date, time, and location will be in your paperwork, so just make sure you pay attention to those. I am going to release you today on your own recognizance. That is your promise to appear at these hearings, but you do have written conditions. You're not to possess or consume drugs without a valid prescription, and you're not to drive a motor vehicle without a valid driver's license. This will be in your paperwork, ma'am. Did you have any questions?
Yeah, it's all a mess. I'm here from South Carolina to take care of my grandpa. That court that I had for a thing, when I came, I went to Mesa, and they said that I didn't, because I was late. Like I said, I'm not from here. I'm here. I can't take care of my grandpa. He's in hospice. But they said that I just had to go in there and pay $100 ticket. But it's fine. I'll just fix it.
Yeah, unfortunately, I don't have any additional information other than that they indicated you failed to appear on February 6th of 2025 and issued this warrant. Make sure you go to your next hearing and you can discuss whether or not it's just a matter of paying the fine. I just don't have that information today, okay?
And the second one, I know you hear this all the time. I've never been in trouble, especially for this. It's really scaring me. And so, will I be able to get a public defender, or should I mean, I had boxers on. Listen, I told them the whole truth, everything I come. I had boxers on that were my boyfriends, and the stuff was inside the boxers. I didn't even know they had pockets inside there.
Talk to your attorney about that. I have appointed an attorney. I don't want you to say too much on the record here today because your attorney is not here, but this is being recorded. So any defense you may have to this charge, speak to your attorney in private. You'll meet with that attorney at your next hearing on June 5th at 8:30.
Thank you. I was just really scared though, because I have a business, and I can't have that on my record. I went to, you have business going, but okay, I will. So thank you so much. That's it.
Step to your left, the officer will get that for you.
Thank you.
Marcus Milius to the podium. Eileen Oliver to the chair. Can I get your name and date of birth?
Marcos Bernard Milius, 2/25/84.
Thank you, sir. You are here today on a new case. It is for 1 count of theft of a credit card, a class 5 felony, 5 counts of fraudulent use of a credit card, a class 1 misdemeanor, and one count of theft, control of lost property, a Class 1 misdemeanor.
Yes, ma'am.
Probable cause has been found, and I'm appointing an attorney to represent you. You're going to have a status conference June 5th at 8:30, preliminary hearing June 9th at 8:30.
Yes, ma'am.
I'm going to release you today on your own recognizance. That is your promise to appear, but you do have written conditions of release. You're not to initiate contact with any alleged victim, complainant, or witness.
Yes, ma'am.
This will be in your paperwork, sir. Did you have any questions?
I will be in rehab, but I will be coming back and forth because I got pulled out of rehab. So I will be back in rehab.
Okay.
I leave, but I'll be coming back and forth still. I'll let them know.
Okay, yeah, just make sure you give them these dates, because if you fail to appear, a warrant would
The
issue.
paperwork will have my dates on there?
It'll have the dates,
Okay.
times, and location.
Thank you, ma'am.
All right, thank you, sir. Eileen to the podium, Catherine to the chair. Good morning. May I get your name and date of birth?
Eileen Marie Olivier, 7/12/64.
Thank you. You are here today on a new case.
Yes.
It is for one count of dangerous drug possession, a Class 4 felony, and one count of drug paraphernalia possession, a Class 6 felony. For purposes of today's hearing, I'm not finding probable cause for these charges. It doesn't mean they're dismissed. It means I don't have enough information today. They may test the substance and move forward with these charges. So I'm still going to appoint an attorney to represent you, and I'm going to give you some hearing dates. You're going to need to attend these hearing dates. Even though I'm not finding probable cause, if you were to fail to appear at these hearings, a warrant would still issue for your arrest. Your status conference is June 5th at 8:30. Your preliminary hearing is June 9th at 8:30. Because I'm not finding probable cause, you're being released as to these charges, but make sure you attend those hearings, okay? Any questions, ma'am?
No.
Please take a step to your left and the officer will get
Thank
that
you.
for you. Thank you. Catherine to the podium, Adam to the chair. Good morning. May I get your name and date of birth?
Catherine Sorensen, October 8, 1969.
Thank you, ma'am. You're here today because there is a warrant that was issued out of the state of Florida, and Florida has indicated that they want to extradite you back as it relates to these charges. They do indicate these charges relate to trafficking stolen property, and this warrant issued, trying to see what the date of this warrant is. Looks like this issued August 26th of 2019. They did confirm that this warrant is valid and they do want to extradite you. Did you get an opportunity to review the laminated card that was given to you?
I had trouble seeing it.
Okay. I'm going to go over what that laminated card discussed. You're going to be given a choice today. You're going to have two options. Your first option is you can say, yes, Florida, I'm ready to come back. If you were to choose to do that and waive your rights and say Florida could come pick you up, you would remain in custody here in Maricopa County and you would be held non-bondable. Florida would have 30 days to come pick you up. That 30 days would start tomorrow as long as you don't have any charges pending here in the state of Arizona. If you have charges pending here in the state of Arizona, then the 30 days for Florida to pick you up would not start until those cases were concluded. Or in the alternative, you have the right to demand that a governor's warrant be signed by both the state of Arizona and the state of Florida, demanding that you are to be returned before you are extradited back to Florida. In that case, I would set a hearing here in Maricopa County on June 1st at 1:30 in the afternoon. That hearing is civil in nature, and what that means is I could not appoint an attorney to represent you here in Maricopa County as it relates to the extradition process, but you could hire an attorney at your own expense if you would like. That process takes about 60 to 90 days. You would have a bond in that case. It is a secured appearance bond of $10,000. So what that means, if you posted that bond, you would be released from custody, but it would still be your responsibility to make sure you came to the hearings here in Maricopa County. If you were to fail to appear at a hearing, a warrant would issue here in Maricopa. You'd still have a valid warrant in Florida, and you'd also forfeit the $10,000 bond that you posted. But if you're unable to post that bond, then you would remain in custody during that process of 60 to 90 days while you awaited for the governor's warrant to determine whether or not a governor's warrant was to be signed. So that's your second option. Do you know what option you would like to do here today, ma'am?
I need to stay in Arizona.
Okay. So you're not required to sign that. So what I'll do is I'll set that hearing June 1st at 1:30 p.m. You have a secured appearance bond of $10,000. If you post that bond, again, you'll be released. Make sure you attend your hearings. If you fail to appear, a warrant would issue, and then you'd have 2 warrants, a warrant here and a warrant in Florida. That takes care of everything. Do you have any questions for me?
Yeah, so I'm gonna be held here.
If you don't post your bond, you'll remain in custody. You won't physically stay in this building, but you will stay in custody of Maricopa County Sheriff's Office.
Till June?
To your next hearing on June 1st, unless you post that bond.
What's this month, May?
We're May 22nd, so you're,
Oh, okay, June 1st?
a little
Okay.
over a week maybe.
Oh, and then I'll be, okay, June 1st?
That's your next hearing date. I don't know that you'll be released. It depends on what happens, but that's your next hearing date, okay?
Yeah.
All right. If you'll go back into the gallery, they'll bring you out your paperwork. Thank you, ma'am. I'm going to put the house calls on the record because we will need to clear our courtroom for the next one. Case number 20 and 21 will proceed as a house call due to refusal to comply with orders from the officers. Alaya King, date of birth July 19th, 1997. She is here today on 2 probation violation warrants with allegations that she violated terms 3, 4, 5, and 15. I'm appointing an attorney and setting a probation revocation hearing May 28th at 8:30. I am affirming the secured appearance bond of $750 in each case for a total bond of $1,500. In the event she posts that bond and is released from custody, she has written conditions. She's not to possess weapons or alcohol, and she must contact her probation officer within 72 hours. Case number 7 will proceed as a house call due to being a danger to self and others. Jaron Vaughn, date of birth October 2nd, 1998, is here on a new case for 1 count of aggravated domestic violence, a Class 5 felony, 1 count of criminal damage, a Class 2 misdemeanor. I am finding probable cause and appointing an attorney to represent him. He's going to have a status conference May 29th at 8:30, a preliminary hearing June 1st at 8:30. He does have a secured appearance bond in the amount of $1,500. In the event he posts that bond and is released from custody, he has written conditions. It does include not returning to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. All of this information will be in the orders I provide to the parties. If anything changes after I meet with them, I will update the written record. And is our courtroom cleared?
Yes, ma'am.
Thank you, officer. Can I have Adam to the podium? Can I get your name and date of birth?
Adam Montesinos, 06/26/2005.
Thank you, sir. You are here today on a new case. It is for 1 count of sexual exploitation of a minor, a Class 2 felony, and 2 counts of sexual conduct with a minor, a Class 6 felony. Probable cause has been found, and I am appointing an attorney to represent you. You have a status conference May 29th at 8:30 and a preliminary hearing June 1st at 8:30. You do have a secured appearance bond of $50,000. In the event you post that bond and are released from custody, you will be released to the supervision of pretrial services, and you'd be equipped with electronic monitoring. You also have written conditions of release. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness, not to have any contact with minors. This will all be in your paperwork, sir. Did you have any questions? Please take it.
I have one question. I wouldn't be released today?
You have a bond of $50,000. If you post the bond, you'll be released from custody. If you're unable to post the bond, then you will remain in custody and you'll be transported to your hearings.
Okay.
Anything further?
No.
Please take a step to your left, and the officer will get that for you. This does conclude our 8 a.m. calendar, and we will now stand in recess until 11 a.m.
Thank you. Please be seated. Do we have our interpreter on the line?
Yes, good morning, Your
Yeah,
Honor.
thank you. Good morning. All right, I think our single person has the headphones, so I'll just start going. All right, this is the initial appearance calendar for 11 o'clock on May 22nd, 2026. Court's orders for the taking of fingerprints and DNA samples made on the 2 a.m. calendar on the first of the month will also apply to these hearings. Before I call the first person up, I am going to read the victim's rights advisement in the event that there are any victims observing the proceedings, either here at the jail or remotely. If you are the victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law, among others include the right to be treated with fairness, respect, and dignity, the right to a speedy trial, to be present at all court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution of a person who is convicted of causing you loss. If you've not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. All right, let us go ahead with Mr. Martinez. If you please come to the podium. Good morning, sir. May I have your full name and your date of birth?
Mi nombre es Jesús Hernández Martínez, 1226 de 1982.
My name is Jesus Hernandez Martinez, 1226, 1982.
Thank you. You have been arrested in a new case. You are accused of aggravated assault with a deadly weapon or dangerous instrument, which is a Class 3 felony under Arizona law. Criminal damage in an amount over $1,000, which is a Class 6 felony. I just want to check. One moment. I want to check something on your paperwork. Okay. I do find probable cause for both of those allegations, and I am appointing a lawyer to represent you. Your next court date will be a status conference, May 29th at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be June 1st at 8:30 in the same court. The address downtown will be on your paperwork. And in this case, you have a $5,000 secured appearance bond. Secured means you can use the services of a bail bond company to possibly post bail for less than the full amount. You have other conditions of release that will be in writing. Those include absolutely no contact with the alleged victim, no weapons, no drugs without a valid prescription, no alcohol. Do not leave the state without the court's permission. Everything else is on your paperwork. If you'll please step to your left, the officer will give you your copy and you can hand him the headphones. Thank you. All right, and if the interpreter could make a general call for service before I let you go, that'd be great.
Yes, Your Honor. ¿Hay alguien más en la sala que necesita los servicios de un intérprete de español?
Okay, I don't see any hands. Have a good day. Thank you very much.
Thank you. You too. Bye-bye.
Okay, bye-bye. All right, can I have Mr. Eli Johnson come in, please? After that, Uriah Abeta, will you please go to the chair? It'll be after that. All right, sir, may I have your full name and your date of birth, please?
My name is Eli Von East. My date of birth is October 6, 1987.
All right, will you spell Vice? I've seen it in the Form 4,
Yes,
the
ma'am.
police paperwork, but I want to know how you spell it.
It's VONEAST. No hyphenations, just one word.
VONEAST.
Yes, ma'am.
All right, I'll copy that for the next one. All right, sir, you are before the court on 3 matters. 1 is a new case, 2 are warrants in pending cases. I'm going to start with your new case. You're accused of aggravated assault on a first responder involving any injury, which is a Class 3 felony. 3 allegations of shoplifting as Class 1 misdemeanors. 2 allegations of resisting arrest passively, which means by running away, as Class 1 misdemeanors. The offense dates alleged range from the earliest is April 16th of 2025, and the latest is August 27th of 2025. Based on what the police have submitted, the court does find probable cause for all of those, as I've noted in my order. I find probable cause for the aggravated assault on the officer by recklessness. And under Arizona law, an assault can be committed recklessly, and I'm going to read you the law. It means that a person is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstance exists. So even though the officer is alleged to have jumped a fence in pursuit of you and injured himself that way, the court finds that on the legal standard, your actions were reckless with respect to that result. So you can talk to your lawyer about all of that. I'm saying that sort of for purposes of the record as well. On the recklessness standard, I believe that the circumstance existed and the elements were met for a reckless causing of an injury to a police officer. So just so that's clear to you. And
Can you tell me when that, I don't mean to interrupt, but can you tell me when that was?
Oh, that was the August 27th, 2025 incident. So, and you can talk to your lawyer more about that.
Okay.
But that was from August of 2025. All right, so I am appointing a lawyer to represent you. It will be the same person that I'm sure that you have for your other 2 cases.
Okay.
You know, everything will come together in the system. Right now, your cases are at substantially different stages of the proceedings. So for the new case, you're going to have different court dates. For the pending cases, you're going to go back to your trial judge. So I'm going to start with the new case only. Your next court date is May 29th, which is a week from today, May 29th at 8:30 in the morning, with a preliminary hearing the following June 1st, which is the Monday afterward, which is 8:30 in the morning. In between those, you're going to have a bail eligibility hearing in the new case only, because you are not eligible for bail today. You've come in with probable cause for at least 1 felony committed while you were on release in any felony case, and you were on release in 2 felony cases on August 27th of 2025. So that means under Arizona law, you cannot be given bail before there is a bail eligibility hearing.
Okay.
That is not today. So today you are held no bond. In a week, you'll have a bail eligibility hearing, which is at 1:30 p.m. on the 29th. So in the morning, you'll go to the status
On the
conference.
20, you said the May.
29th.
Okay.
It's 1 week from today. So in the morning, you go to the status conference. In the afternoon, you have your bail eligibility hearing. On your paperwork, it'll say evidentiary hearing because it is an evidentiary hearing. But I try to remind defendants when you're trying to think, when is my bail hearing? It's the one called evidentiary hearing. But you'll see your lawyer in the morning that same day, and you can talk about what's going to happen at the bail hearing in the afternoon.
Okay.
So that takes care of the new case. You don't have any other release conditions because you're not being released.
Okay, so my question to you is, if I may, I'm charged with someone falling.
Correct. In pursuit of you, yes, correct. So
Okay.
talk to your lawyer about how that works.
Yeah, no,
I find probable cause that your actions, as alleged, I know you're not convicted, constituted recklessness under the meaning of the law, and that is a legal theory to hold you criminally responsible for that injury. So talk to your lawyer about how that works. I recognize you are not accused of punching a cop or anything like that. You are not accused of that, but you're accused of causing an injury by recklessness. So talk to your lawyer about how that works.
So he fell and I'm...
Correct.
Really?
Yes, you have that correct.
Yes,
All right,
ma'am.
now, you're also here on 2 bench warrants for failing to appear in the trial court in 2 separate cases, numbers 12 and 13 on the calendar. And I have to read you the charges. In number 12, it appears you've been charged with shoplifting as a Class 4 felony, 2 allegations of removal of a theft detection device, those are Class 6 felonies, 1 allegation of passively resisting arrest, a Class 1 misdemeanor, 3 allegations of misdemeanor shoplift as Class 1 misdemeanors. Those all have offense dates in June of 2025, and your post-warrant status conference is going to be, in that case, this is also going to be June 1st at 8:30 in the morning, and the court will end up reconciling that June 1st court date.
So what does that
Meaning,
mean?
I gave you a preliminary hearing on June 1st as well in the new case, but
Everything's going to
when
be
you
consolidated.
go on the 29th, I think they're gonna get organized about where you are supposed to physically be on the 1st, because I'm locked into those dates. So I'm ordering you into Judge LaBianca's court on June 1st at 8:30. I'm also ordering you into a preliminary hearing in the new case in a different court. Work with your lawyer, that they work these things out downtown.
Does the lawyer that I have on file, is his name David Goldberg?
I believe it is, yeah, that's
Okay, so Your Honor, Mr. Goldberg, in regards to my the felony warrants, Your Honor, my attorney gave falsified.
Okay, that is absolutely nothing this court can resolve today.
Okay, yes.
No, we're an initial appearance court, so
Okay.
we just do this hearing to determine release conditions, get you your court dates, and you move on.
Okay.
This is not a contested here, well,
Okay.
it could be contested, sure, but not on that topic.
Yes, ma'am.
We don't do any other topics. So if you want to do a motion for new counsel, if you want to say to the judge, he lied about me, et cetera, you're going to have to do all of that with Judge LaBianca. That this court, I can't take evidence. I literally cannot legally take evidence at this proceeding
Yes,
to
ma'am.
determine whether I believe you or not.
Yes, ma'am.
So you need to take all that up with Judge LaBianca. So it's not that it's never relevant. It's just today, I am in zero position to determine whether you're telling the truth.
Yes, ma'am.
And so,
Okay,
so I just need to keep going.
So if I, for instance, if I go into Judge LaBianca's court and I give her my evidence and everything like that, if she wanted to reinstate my bond.
Yeah, it's her case. It's her case. She can do what she wants.
Is that going to would that still affect the
no bond?
Yeah.
It would not. No, first you have to go to the status conference and the bail hearing there, which are not in front of her. That's in front of a different.
So I
judge.
go to another judge and then explain to them.
Yes, and then eventually the cases have to come together in the system. But you're not being held no bond because you had a warrant.
Yeah.
Even if you didn't have a warrant, you would be getting held no bond.
Yeah.
It's the fact of the open case. If it's open at all, even if you've been coming to all of your court hearings.
Yes, ma'am.
If you come in on a new felony, the Arizona Constitution says you don't get bail. The rules say you do get a bail eligibility hearing. So.
And that is.
Talk to your lawyer. That's in 7 days.
And that is literally discussing whether or not I'm eligible.
To test the strength of the state's evidence and
Okay.
determine whether you might be eligible. So talk to your lawyer. Your lawyer will go through all that with you.
Okay, thank you so much.
All right. Now, in each of these two, so I read you the charges for number 12 and number 13. The charges are armed robbery, a class 2 felony, theft as a class 2 felony, trafficking stolen property as a class 2 felony, and 4 allegations of aggravated assault with a deadly weapon or dangerous instrument, and those are all class 3 felonies, and those all date from June of 2024.
Okay.
So you still have a lawyer in these cases. Your court date is going to be, and if you want to do a change of counsel, that's Judge LaBianca.
Okay.
So you're going to have a status conference June 1st at 8:30 in the morning in her courtroom, and I'm affirming her bond for you, which is $100,000 cash only in each case. That is
$200,000?
Cash only. They have
Cash.
forfeited your prior bond. There's an order in the docket. The bail bond company had to pay on your former bond. So you have to put that up in
So
cash.
there's no way for me to even put the collateral up
Correct.
and then put it. Wow. Okay.
It's been forfeited. So go ahead and step to your left. They're going to give you paperwork for everything. You're back in court next week.
On June 1st.
Yeah, but
And
you'll be in on the 29th, so you should be able to talk to your lawyer about everything.
Is that going to be moved at all, or for sure is that going to be on?
If you get indicted, it'll be moved. So I don't know.
Well,
I have no control over that.
Okay. And
No
I
knowledge.
haven't been indicted on anything.
No, you just got arrested.
Okay.
Yeah, it's up to the county attorney now to decide all that.
Whether they want to pursue with the charges
Correct.
or not. So if they decide not to pursue the charges,
Then the new case would go away,
Mhm.
and you would just be left with the old case.
and then I can go explain to her what happened, and she can enter. Okay.
She'll make a decision. Yeah.
Okay. Thank you so much.
All right, sure. Mr. Araya Abeta, and then Juan Mendez, we go to the chair.
Thanks.
Hello, sir, can I have your full name and date of birth?
Uriah Abeda, 5/8/1988.
Okay, thank you, Mr. Abeta. You're here on two things. One is a new case and one is a probation warrant. In the new case, you were arrested for 2 allegations of aggravated assault with a deadly weapon or dangerous instrument. That's a class 3 felony. Disorderly conduct, a Class 1 misdemeanor, and 2 allegations of criminal damage as Class 2 misdemeanors. There is
Okay.
probable cause for all of those, and I am appointing a lawyer for you. And I'm also appointing a lawyer in your probation case. You're on probation for a Class 4 felony, and there was a warrant already out for your arrest in this case since February 3rd of this year, because a petition to revoke your probation was filed alleging that you violated terms 3 and 5. You'll get a copy of that petition from your lawyer. All righty, your next court dates are going to be slightly different right now, but they should come together in the system eventually.
Okay.
The first court date is actually going to be in your probation case. It's a revocation arraignment hearing on Thursday, May 28th, 8:30 in the morning. And that address is going to be on your paperwork. Then in the new case, you have a status conference the next day, which is May 29th at 8:30 in the morning, followed by a preliminary hearing on Monday, June 1st at 8:30. In the probation case, the court finds that you will, in all reasonable probability, be revoked to prison in that case. So you do not have bond in that case. You are held no bond today.
Okay.
In the new case, you have a $10,000 secured appearance bond and written release conditions that includes no victim contact, no going to the scene of the crimes, but you are still being held no bond in the
Okay.
probation case, so you shouldn't try to postpone in that case unless you're sure you're going to get out on everything. Everything I just told you is on your paperwork. If you step to your left, they'll give you a copy.
All right, thank you.
Thank you. All right, Mr. Mendez, Juan Mendez. And then Daniel Aparicio, will you go to the chair, please? Hello, sir. Can I have your full name and your date of birth, please?
Juan Anthony Mendez, 11/14/1995.
All right, thank you. You are here on another probation hold. It looks like you came in yesterday and they should have put a hold on you in both of your probation cases. They just did the one, and now, because they always do all of them together. I mean, if you violate a condition of probation in one case, it always violates in the other case too. So anyway, so this is your probation violation in your, I want to say this was a drug case is my recollection. This was a conviction for, oh, it is a warrant. Oh, I lied. You're actually in warrant status in this case. Dangerous drug possession, Class 4 felony. You're on intensive probation, and there was already a warrant out for you. Oh, no.
It was a warrant for the
It
other.
went out yesterday.
Yeah.
Right. Okay, sorry. Because they can get the warrants issued quite quickly once they go that route in probation. That's what's confusing is, anyway, they did get it signed yesterday, May 21st. So it alleges you violated terms 2 and 15 of your intensive probation in this case. All right. You're going to end up with the same lawyer. I'm appointing the public defender for you in both of your probation cases. Even though I'm probably giving you a later court date than yesterday, I'm giving you the 28th, which is Thursday. If you got Wednesday yesterday, they'll be able to do everything on Wednesday. You know?
So go Wednesday?
Well, yeah, right. No, but just like in the other case, I do find that you are highly likely to be revoked to prison. So you don't have bond in this case either.
Yeah.
So sheriffs will take you over. I can double check your court date really fast. Let's see. Oh, no, we gave you the 28th. Okay. So we're able to give you the same one. It just depends on when the calendar fills. Our computer rolls it over to the next person. So it's fine. You're going to go to the same court date and time. You'll get the same lawyer for everything. You can take up everything with your lawyer at once in 6 days.
That sounds great.
You step to your left, you get your paperwork. Thank you. Mr. Aparicio? And then Juan Bello or Bello Cervantes, will you please go to the chair? Hello, sir. Can I have your full name and your date of birth, please?
Daniel Aparicio, 7/11/89.
All right, thank you. You're here on one new case and also a probation hold. In your new case, you were arrested for aggravated domestic violence. It is a Class 5 felony. I need to check one thing on your paperwork. Hold on one second.
Okay.
Okay, I was checking that I forgot to check that you do have the priors to make it an aggravated domestic violence, and you do have at least 2 prior domestic violence convictions within any 7-year period. You do have them. So there is probable cause for the aggravated domestic violence. It's a Class 5 felony, and there is probable cause for misdemeanor assault as a domestic violence offense, Class 1 misdemeanor. So I do find probable cause for both of those. I am appointing a lawyer to represent you. Your next court date is the status conference this coming Friday, 1 week from today, May 29th, 8:30 in the morning in the downtown Superior Court. Your preliminary hearing is going to be June 1st at 8:30 in the same court. You are on felony probation, and the probation department will be filing a petition to revoke your probation based on these new offenses. So you need a lawyer, and you will get a copy of a petition to revoke through your lawyer at your next court hearing, which is actually going to be first. Your court hearing in probation is going to be May 28th at 8:30 in the morning. Then the next day, May 29th, that's your first court date in the new case. All of this will be on your paperwork. All right. In the new case, the court is very concerned about the safety of the alleged victim. Bond is set in your case at $15,000. It is secured. If you post it, you will go out on an ankle monitor under the supervision of pretrial services. That is to categorically keep you away from her. Do not respond to any contact from her. Do not have any contact with her. Domestic violence strangulation is alleged. You weren't booked on that. If you had been booked on that, your bond would have been $25,000. There is a strangulation alleged. It looks like right now the alleged victim declined to have a nurse examination, which is probably why they didn't book you for that, even though the police alleged they observed physical signs of domestic strangulation. Domestic strangulation is a massive red flag for future domestic violence. And actually for DB murder, although I'm not saying that's you, I'm just saying it is a documented and researched red flag, domestic strangulation. That is why it's a felony in Arizona, why the court is imposing these release conditions. You will have absolutely no contact with her, even if she contacts you first. That is very clear in the record. Don't do it from jail. Don't do it if you're out of custody. The bond is $15,000 with an ankle monitor in that case. In the probation case, which is a Class 6 felony, the court has considered multiple factors, and I am going to grant you bail in that case because in this situation, I'm not prepared to say the legal standard, which is that I believe you're highly likely to be revoked to prison in that case. So talk to your lawyer about how that works. I am granting you bail in the probation case in the amount of $5,000 secured with release conditions. That makes your total bond $20,000. And if you post it, you go out on an ankle monitor in the domestic violence case. Everything I just told you is on your paperwork. You can do a civil standby with law enforcement to collect belongings from that location. But that is the one and only way and the one and only time you can go to that location while this case is pending. If you'll please step to your left, I'm going to give you all of your paperwork. Thank you. All right, Mr. Bello Cervantes, and then Samuel Allen Wright, will you please go to the chair? Hello, sir. Can I have your full name and your date of birth?
Hello, Your Honor. It's Joan Bello Cervantes, 9/14/2001.
All right, thank you. You are here on a new case and a probation hold. In the new case, you were arrested for aggravated driving under the influence of alcohol. Sorry, this one reverted the appointment of counsel. I need to reprint it. Sorry, we have a computer glitch that they know about and haven't fixed yet. 1 second. Okay, make sure it took, yep, okay. So we just need to reprint your paperwork. I am appointing a lawyer for you in this case, and also in your probation case. You're on probation for a Class 6 felony. Looks like disorderly conduct with a weapon, and the probation department will be filing a petition to revoke your probation based on this new crime. So you will get a copy of that from your lawyer. You will end up with the same lawyer for both cases. All right, in the probation case, your next court date is going to be this Thursday, May 28th at 8:30 in the morning. Double check that. That'll be a revocation, arraignment, and possible disposition hearing. Then the next day, May 29th at 8:30, that's your status conference in the aggravated DUI case with a preliminary hearing June 1st at 8:30 in the same court. In the new case, bond is set in the amount of $2,500. It is secured with alcohol testing and monitoring if you post that bond. They did not book you for aggravated assault, which really surprises me on these facts. They may yet charge you with it. So I'm warning you, that's another reason to be compliant, because I would absolutely have found probable cause for aggravated assault on these facts, and I would have given you probably a $10,000 bond. But we are required to consider what you're being accused of specifically, and they haven't done that yet. It's going to be up to the county attorney, but they could. Even on this charge, sir, you face a potential 4-month mandatory prison sentence. Did you know that? Well, I hope you're surprised. I hope you're afraid of that. No judge can legally give you less if you are ultimately convicted. So right now, at this moment, you face 4 months in the state penitentiary followed by probation. You can't get a day of probation in a class 4 aggravated DUI. That's nothing to say crashing into someone's house so hard that you pushed their bed. That's aggravated assault. So you need to be very compliant, Mr. Bayo. You will alcohol test. You will not drink. You've not been testing in your probation case. I'm aware of that. So I've decided to give you bail in your probation case as well, even though I'm more than half talking myself out of it right now, but they have not booked you for aggravated assault yet. So your bond in the probation case is $1,000 secured. You haven't been completely in the wind, but my recollection is you've not been testing. And that appears to have been a very poor decision. So talk to your lawyer about that. You need to try to stay out of prison, which means remember that you have the right to remain silent.
I just have a question about you said the thing earlier right now about oh, I had a brain fart, sorry.
I said any person who's charged with aggravated DUI class 4 faces a 4-month mandatory minimum prison sentence. Now, if you're convicted with a prior, you do 2.5 years presumptive. So if you go to trial and lose, the state will allege your prior felony. The presumptive sentence for the DUI alone is 2.5 years in prison. Or actually, it's with one, you're a category 2 offender. It's higher than that. I apologize. I haven't seen the sentencing charts in a long time. It's higher. So right now, you've got a prior felony. You're staring at a potential prison sentence. If you don't comply while you're on release in this case, you're begging to go to prison.
So
I'm just very concerned about this, sir. I'm just very concerned about
when
this
I was
case.
on, so if I'm
You
on
could
probation-
easily have killed that woman last night if you did what they accuse you of doing. Go ahead.
No, if I was on probation, so what is the bond set at right now?
$3,500 total, and you come out with alcohol testing. In the new case, I believe they're already testing you in probation. Well, they're trying to test you.
They haven't told me anything about testing.
All right. So and I read a lot of notes. Oh no, they're trying to get you for proof of employment. So yeah. So talk to them about that. I just said the PO can test you if they want to do it in your probation case. I don't care, but you're gonna test for us. All right. Everything's going to be on your paperwork. If you bond out, comply with that, Mr. Bayo. You're already in a very problematic legal position. You will make it unspeakably worse. And I say this because I am very concerned about what they allege that you did last night. You could easily be standing before me on a second-degree murder charge. Step to your left to get your paperwork.
Thank you.
Mr. Allen Wright, Samuel Allen Wright. And then Jennifer Davis, will you go to the chair? Hi, sir. Can I have your full name and date of birth?
Samuel Leo Wainwright, November 5th, 2001.
Okay, thanks. You're on 1 new case and 2 probation cases. I'm going to start with your probation cases. You're on probation for 2 class 6 felonies, and there were 7 petitions to revoke filed against you last November 26th. They allege that you violated terms 3, 4, and 5. You'll get copies of those from your lawyer, and I am appointing a lawyer for you in probation court. Your next court date will be a revocation, arraignment, and possible disposition hearing in the downtown probation court, May 28th, which is Thursday, 8:30 in the morning. The address is on your paperwork. And I am appointing a lawyer for you if I didn't already say that. I am affirming the probation judge's bond in each of those 2 cases. It is $1,500 secured per case for $3,000 total with written release conditions that do include calling your PO within 72 hours of any release. In the new case, you got booked in for a drug paraphernalia possession allegation. It's a class 6 felony. I'm giving you a lawyer and 2 court dates. Your court dates are going to be further out. The first one will be a status conference June 5th at 8:30. Your preliminary hearing in the new case will be June 9th at 8:30. Those will be in the downtown Superior Court. The reason those are so far out is I did not find probable cause in your case. Don't get too excited. So you still have bond in the other cases, but I'm not adding any bond in this case or anything else. So you get released in the new case only. So That's why I saved it for last. I didn't want you to get excited. You just got a $3,000 worth of bond in your probation case, but you can post it and be out of custody if you want. Everything you need to know will be on your paperwork. Do not miss any of your court dates. If you step to your left, they have that paperwork.
Thank you, Your Honor.
Thank you. All right. Ms. Davis, Jennifer Davis, and then Justin Sanders, will you go to the chair?
Oh, yeah.
All right, podium please, ma'am, and then Mr. Sanders to the chair. Okay. Hi, ma'am. Can I have your full name and date of birth?
Jennifer Davis, 33181.
Okay, thank you. You're here on a warrant for failing to appear in a case in which you've been charged with possessing narcotic drugs. It's a class 4 felony. There was a status conference on February 27th of 2025. When you weren't there, a warrant went out for your arrest. You do already have a lawyer in the case. You still will. Your status conference is going to be 1 week from today, which is May 29th at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be Monday, June 1st at 8:30. I'm going to affirm the bond set by the judge who issued the warrant. It is $1,000 secured. If you post it, comply with all of your written conditions and don't miss your court date. If you step to your left, I have your paperwork. Thank you. And Mr. Sanders, and then Vanessa Marquez, please go to the chair. I feel like I have just a brown cloud in here, comparatively speaking. Hi, sir. Can I have your full name and date of birth?
Justin Sanders, 10390.
All right, thank you, Mr. Sanders. You are here on a probation violation warrant in your class 4 felony case. This warrant was issued October 2nd of 2025 after a petition to revoke your probation was filed alleging violation of terms 3 and 5. You'll get a copy of that from your lawyer, and I am appointing a lawyer to represent you. Your court date in the probation court will be this coming Thursday, May 28th at 8:30 in the morning. It will be a revocation arraignment and possible disposition hearing in the downtown Superior Court. Your bond is $1,000. It is secured. If you post it, comply with all of your written conditions. You have to call the probation department within 72 hours of any release from any jail. It's a term of your probation. My orders will include the main number for probation. If you bond out, you will not have a valid excuse for not calling the probation department. They will connect you with your PO, assuming, as I do, that you don't know who that is. If you'll step to your left, they'll give you a copy of that. Ms. Marquez, Vanessa Marquez, then Anthony Rodriguez. Will you please go to the chair? Hello, ma'am. Can I have your full name and your date of birth?
Vanessa Marquez, July 24th, 2000.
All right, thank you. You're here on a new case. You were arrested for unlawful flight from a law enforcement vehicle. It is a class 5 felony. Endangerment, class 1 misdemeanor. DUI alleged 2 different ways. One is while impaired to the slightest degree. The other was with a blood alcohol of 0.08 or more. Those are class 1 misdemeanors. Reckless driving, which is a class 2 misdemeanor. Possession of an open container of alcohol in a vehicle, which is a class 2 misdemeanor. And criminal speeding, which is a class 3 misdemeanor. There is probable cause for all of those crimes, and I am appointing a lawyer to represent you. Your next court date will be in 2 weeks. The status conference, June 5th at 8:30 in the morning in the downtown Superior Court. Preliminary hearing, June 9th at 8:30 in the same court. Now, in your case, I did give by our standards, a considerable amount of thought to what to do. You do not appear to have any criminal history. What they accuse you of is the type of lengthy and dangerous police chase that does make other people die on a regular basis. And that they apparently had to use, as I recall, they had to use a grappler. They had to follow you with the air unit, and that this went on for some time, and there was a lot of bad driving observed, so they allege. And here you are with no criminal history, apparently 2 children who I assume you would like to continue to parent.
Yes, ma'am.
So that is a bit of a conundrum. Also, this is a probation eligible offense if you truly have no criminal history. It is also very dangerous. It is the type of case scenario where typically this court will set between $5,000 and $25,000 easily for this. And you have no criminal history. There also appears to be a very strong weight of evidence against you. They have to prove it beyond a reasonable doubt. But what they've alleged, if they have all of this evidence, they'd have what I would call a good case. So the public safety factor in your case is rather extreme. I'm going to try to reconcile all of these, but I want you to understand that this is the type of behavior that gets people a bond all the time in this court. I'm gonna put you on an ankle monitor and make you drug and alcohol test. And I'm gonna let you go without posting money.
Thank you.
You must comply. Also, if you had been accused of hurting a single person, you would just be getting a bond.
Yes.
And it probably wouldn't have been small.
No.
Also, it appears that if you did this, you got very lucky and you didn't hurt other people. So, I'm going to release you on an ankle monitor. That's to try to keep track of you because what they accuse you of is so shockingly reckless. Please focus on compliance. I believe that having the kids and never being arrested before should be operating as a strong incentive to comply. I don't decide if you did it. I try to set release conditions that I think will result in compliance. Compliance means showing up for court, complying with conditions, not committing new crimes, which is the very first release condition. Don't commit new crimes. Don't hurt anybody. Don't violate your release conditions. Will you comply with all of the court's orders and come to court as ordered?
I comply.
All right. And I'm going to release you on an ankle monitor. You're going to have to drug and alcohol test. You're going to get an envelope. After you get out, you call in. They'll start setting up the testing. The more times you test, the more your lawyer could argue, for example, that you're not an addict, meaning to alcohol or anything else, and that you can control your behavior so that the community is safe. So I always tell people, the sooner you give your lawyer a good argument that you're complying, they can ask to get the ankle monitor off of you. They can ask to stop the testing. That'll be up to the court.
Okay.
But compliance is what gives your lawyer a good basis to argue for that.
Okay.
So status conference in 2 weeks, June 5th at 8:30. Preliminary hearing, June 9th at 8:30. All that's on your paperwork. I am appointing a lawyer for you. And you've got your other orders. So no drinking at any point, at any time, 24 hours a day, zero drinking while the case is pending. And obviously, no illegal drugs. Everything's going to be on your paperwork. And if you'll step to your left, they're going to give you a copy. Thank you. Mr. Rodriguez, Anthony Rodriguez. And then Sakeo Zuniga, will you please go to the chair? Hello, sir. Can I have your full name and your date of birth? Right here to the podium.
All right.
Thank you. Yeah.
Yeah, Anthony Rodriguez, 72981.
All right. Thank you. You're here on a new case. You're accused of domestic violence, criminal damage. Domestic violence is a legal term in Arizona. Criminal damage as a Class 6 felony and domestic violence offense. Assault, a Class 1 misdemeanor and domestic violence offense. There is probable cause for both of those crimes, and I am appointing a lawyer to represent you. Your next court date will be a status conference June 5th. That's in 2 weeks, 8:30 in the morning in the downtown Superior Court. Preliminary hearing June 9th at 8:30 in the same court. And in your case, I have considered that the felony alleged is criminal damage by the smashing of a phone. And that you do, however, have a misdemeanor conviction. It's old, 2002 for domestic violence, and that's it. So I'm going to put you on an ankle monitor. I'm very concerned about keeping you away from the alleged victim. The police stated the alleged victim told them she does not want to press charges, which isn't up to her now. It's up to the Maricopa County attorney. She can be forced into court under a subpoena or a warrant. And so domestic violence cases are ones where the court very much worries about victim intimidation and retaliation. And one of the documented, researched red flags for future and, in fact, ongoing domestic violence is when people are confident enough in their domination of the other person to assault them in public. And so yours is a case where you are accused of assaulting someone in public to the point where another person was frightened for her into calling the police. So you're not to have any contact with whoever called the police. Absolutely no contact with the alleged victim, even if she calls you and invites you to have contact with her. That's very clear on this recording, very clear in my orders. You are not legally allowed to respond to her. It is at a minimum a misdemeanor. If whatever you do could arguably be one instance of harassment, which could be a single text, then that is aggravated harassment because you're under a court order not to contact her. That would be a new felony. We would hold you no bond at the initial appearance. You may do a civil standby with law enforcement to collect belongings from that location. That is the one and only way you can physically go there while the case is pending. Don't contact her through third parties, nothing. No weapons, no drugs, no alcohol. If you get served with an order of protection, you must comply with that as well. But I'm not going to make you post a bond because I recognize that your criminal history is not massive, and that the felony in this case is a property crime. The assault is a misdemeanor. That being said, this court is empowered to make orders to protect any person or the community in general, and this court believes on these facts with a third-party witness doing it in public, that is a serious red flag for not only future DV, but it's a strong indicator for ongoing DV. So comply with your release conditions. Do not violate them. Do not miss your court dates. Okay?
Yeah.
All right. If you step to your left, you get paperwork. All right. Mr. Zuniga or Zuniga? Here you go, sir. Sorry, I hear both pronunciations. I'm never sure which a person likes to use. What's your name, sir?
Sakeo, Sakeo Zuniga,
Which date of birth?
February 9th, 1999.
Okay, thanks. You're here in Peoria. City court warrants in a disorderly conduct case. It's a misdemeanor. Your arraignment hearing is going to be June 9th at 9 in the morning, which is over 2 weeks from now, June 9th at 9 in the morning. I'm going to release you on your own recognizance in this case. The public access records that I could find indicate that you didn't provide proof of compliance with anger management or education, treatment, whatever, that that you've been in a, I think maybe a deferred sentencing or something, that you have a deferred prosecution. You're in some kind of deferred prosecution.
Yeah,
You're supposed to do anger management. You didn't do it. They sent you angry letters and you ignored them. This is what happens. But you haven't missed a court date that I could see. Comply. I'm going to release you. Go to court, June 9th, 9 in the morning. Get straight with them or this happens again. If you don't go on June 9th, then we're going to give you a bond the next time we see you, okay? So, because my job is to get you to go to court, comply with release conditions. Right now, obviously, they see you as low risk. You're in some kind of deferred prosecution program.
Yeah.
You're just not complying. Show up, okay? Everything's on your paperwork. If you step to your left, I'll give you a copy.
Am I getting released?
Yeah.
Thank
Release
you.
That's what I'm trying to get you to go to court because the only reason you spent a night in jail is you didn't, you didn't pay attention to them. Go to court.
My address.
Make sure your address is updated, and then we won't see you again.
Yeah.
All right. Thank you.
Thank you.
Good luck. Mr. Allen, Jordan Allen, and then Alan Pantoja. Go to the sheriff. Hi, sir. Can I have your full name and your date of birth?
Jordan Allen, 9/25/1996.
Okay, thanks. Mr. Allen, you're here on a warrant from the Buckeye City Court. And this is, you're the one. You're in a deferred sentencing program for a shoplifting case. It's a class 1 misdemeanor. It looks like if you do all the things they told you to do, then they'll dismiss. So they set a hearing to talk about you not complying and you weren't there. But I'm going to release you. Go on June 9th at 2 in the morning. Talk to them about whatever it is they believe you haven't done. Keep straight with them and you won't get arrested ever again in this case.
Yeah.
If you don't go on June 9th, we're going to give you a bond because the whole point of this hearing is to get you to go to court. If you won't go, you're going to end up having to pay money to get out the next time we see you. It's a lot easier to go. Or call them in advance if you can't go that day, if you have to work or something. Call before June 9th.
Yes.
Ask for a new court date, okay?
Yes.
Don't ignore them or we will see you again, all right?
Yes.
Everything's on your paperwork. If you step to your left, you'll be all done. You'll be released in a few hours, okay?
Okay.
Try to be patient. It does take quite a few hours.
Okay. Thank you.
All right, sure. Mr. Pantoja and then Holly Bilnard, will you please go to the chair after Mr. Pantoja?
Morning, Judge.
Hi, sir. Can I have your full name and your date of birth?
First name is Align, last name Pantoja. Date of birth is 11/30/1989.
Okay, thanks. And it looks like, one second, you guys brought the house call, right? Number 6? I think I see, because I see Mr. Walker in court. Are you Ms. Walker? Okay, you can stay right there. I'm just saying we had you listed as me going back there, but I see you, so we'll just unmark it. Okay, all right. Oh, okay, see, that's always what happens is it means somebody else got marked. Okay, who's your house call? 1 second.
I'll call it Murray.
Murray? Oh, Sherry Murray Powell? Okay.
Yes.
Okay, thank you. You can fix that, right? Okay, thanks. Okay. I apologize. None of that had anything to do with you.
Not a problem.
What's your name and date of birth, please?
First name is Align, last name Pantoja, date of birth is 11/30/1989.
Okay, thanks. You're here on a warrant from the Ajo Justice Court, which I feel like is in Pima County, but I
It
don't look
is.
it up. Okay, thanks. And this is, for interfering with judicial proceedings. You have already been convicted. It's a class 1 misdemeanor. Your arraignment hearing in the Ajo Justice Court is scheduled for this Thursday, May 28th at 8:30 in the morning. That's just 6 days from now. I'm going to release you on your own recognizance. There's no indication that I could see or in the public access records that this is a failure to appear. And this case has been going on a long time. You've gone to some hearings and it looks like you just stopped talking to them, let your address lapse and whatever around about December of 2024. So guess what happens? If you don't go, you're going to get an ugly surprise at some point in the future. But you didn't try to hide from the cops, even though you probably knew you had a warrant. You need to go. If you don't, we're going to see it. It comes up in little lines and be like, oh, I can do the math. You just blew it off. Just go. I don't know that you'll ever do another night in jail. I don't know your case, though.
No, appreciate you.
All right, just
Understandable.
do the math.
Of
It's
course.
easier to go.
Yes.
Step chill out.
Thank you.
All right, Ms. Bilnard, Holly Bilnard. Then Eric Lozada Alvarez. We go to the chair. Hello, ma'am. Can I have your full name and date of birth?
Yes.